Good morning, everybody. All right, we are going to get started. And Mimi, are you going to start with the roll call, please?
Okay. Justice Edmond?
Here.
Toby Rothschild?
Here.
Joyce Raby?
Here.
Andrew Arruda?
Here.
Simon Bomey?
Here.
Tara Bird?
Here.
Judge Wendy Chang?
Here.
Abhijit Shaban? Jean Clausen? Johan Droshagen? Margie Estrada? Lori Gonzalez?
Here.
Richard Grammy?
Here.
Andrew Kuchera? Joanna Mendoza?
Here.
Kevin Moore? Heather Morse? Daniel Rice? Alan Rodriguez? Daniel Rubens?
Here.
Mark Tuff?
Here.
Joshua Walker. Thank you.
All right, let's take a call for public comment. Is there anybody here who wants to speak to our issues before we get started? All right, hearing none, we are now going to introduce a brand new member. Simon Bomey has joined us for his first meeting. Simon, welcome. Why don't you tell us a little bit about yourself?
Hello, my name is Simon Bomey, and I'm so honored to be here with friends and colleagues and look forward to getting to know all of you more over the next year. I am a mediator and an entrepreneur. One of my ventures have been successful, two of them not so much, and all of them, though, have been mission-driven to access to justice. And so I'm eager to share my experiences bootstrapping these legal tech companies and speaking with customers, speaking with people who really need these services, and just sharing this with you all today. And so very excited to be here. Thank you.
Welcome. We're thrilled to have you. And Simon's got it down. If you are going to speak, you ought to press your mic, make sure it's on so that everybody can, who's participating by phone can hear. We opened it for public comment, but hopefully you all have seen a copy of the letter that came in from Off the Record. And Mark, I understand that you received some materials. You want to speak to that?
Yes, good morning. Laurel Terry. Is that not? Oh, thank you very much. Laurel Terry, who's a professor at the University of Pennsylvania School of Law, who's an international expert on professional responsibility and things of that nature, sent a link, which I then forwarded to Mimi and Andrew and Randy, on the Australian study on artificial intelligence and ethics. And I didn't realize that it also had the gigantic report attached to it, but so I sent that on to them, and I assume they're going to circulate to everyone on the committee.
Okay.
The point is, there's a lot of interest in our committee around the world as well as around the country.
Terrific. Thank you. We're going to move to the staff report. Randy's got a number of things he wants to report on. So, Randy, the floor is yours.
First thing I want to mention is that between meetings, we did confirm the addition of 2 meetings. The August meeting of the task force will be on August 9th here in San Francisco. It was the date that had the most available participation, so please lock that into your calendar. It will be a task force meeting here in San Francisco on August 9th. And directly after that, on the 10th, August 10th will be the public hearing that we're going to request that the board authorize so that we have an opportunity to coincide with the ABA annual meeting, which is also in San Francisco this year. So the ABA will be in San Francisco for a few days, just at that same time frame. And we wanted the synergy of being able to get any of those stakeholders who are in attendance at that event to be able to come and provide all the input or wisdom that they want to share with us on our activities. We understand that there's a number of other jurisdictions who are conducting similar studies or have completed their own future studies, and we would be outreaching to them to appear at our public hearing and give us information. I wanted to clarify, though, that the activity on the 9th is a task force meeting for which we need a quorum. So if you've confirmed with Lauren that you're going to attend, please do attend because we need a quorum to conduct that meeting. The activity on the 10th, which is a public hearing, does not require a quorum. And so whoever is available to stay over on to the next day and appear and receive the testimony, we would welcome as many members of the task force who can attend.
Will the second meeting, the public hearing, will that be held here so it can be a live webcast as well?
Do we have the webcast room? Yes? We did secure this room, so it can be webcast.
Okay, great, thank you.
Will an email be circulated with that information for folks to be able to add it after this meeting to their calendar?
Yeah, was there a new revised calendar circulated?
Yes. Thank you.
The second thing I want to report on is that last Friday at Stanford University, Margaret Hagan, in cooperation with Codex and the Stanford Design Lab, held a regulatory sandbox on the issue of legal tech. And with us this morning is State Bar CEO Leah Wilson, and she was also in attendance. At one point, Josh Walker was also going to attend, but he had to bow out due to a last-minute conflict. Actually, I'll invite Leah if she just wanted to say anything about the sandbox before I sort of give my brief overview.
I don't know what your overview is going to cover, and I don't want to be repetitive, but it was really interesting as I think this slide illustrates, certainly for Randy and I that don't get to attend these kind of interdisciplinary meetings at fine research and educational institutions that often. It was a really different format. This design lab has actually been contracted with by the Utah Supreme Court to explore precisely the issues that this task force is looking at. How can regulatory reform be responsibly implemented to increase access to justice? And they are specifically looking at adopting a model that I now understand has been used fairly broadly in fintech regulatory reform, where there is a sandbox period, a moratorium or a reprieve on the implementation of any kind of regulatory standards that might prohibit innovation in a certain space for approved entities for the sandbox period. So in fintech, that period is fairly brief. As I understand it, 6 to 12 months. We discussed on Friday perhaps a longer period for the legal version of the regulatory sandbox, but the idea would be that approved entities for a specified period would be allowed to operate free from identified constraints, including various rules of professional conduct or various statutes, so that they could innovate. And during that period, those innovations would be evaluated to determine or assess their impact on articulated goals. In this instance, state of Utah very interested in increasing access to legal services. So that is the goal upon which these businesses or entities would be evaluated. So it was really interesting. We were all there to kind of give Utah ideas on how they might implement this, what kind of entities might be interested in taking advantage of the sandbox period, and it was quite relevant to what we're all talking about here.
And that's an excellent summary. Let me just say that I did not quite understand the concept of a regulatory sandbox going in, but I do have a better understanding now. And what it really suggests is that when you're considering very sweeping regulatory reforms, something like what we are looking at in terms of changes to statute, changes to rules of professional conduct, changes to how regulatory bodies enforce and operate, who falls under regulatory jurisdiction, that you might not want to proceed with just the normal operational model where a committee or a body comes up with possible changes in the law or a new regulatory agency, that is put through its paces through public comment, that it comes back to the regulators, and then they decide, well, we're going to change these, and maybe we're going to have a new type of regulatory institution on a pilot basis, and we're just going to make it happen. And if it works, it works. If it doesn't, it doesn't. This regulatory sandbox envisions something that is much more, I'd say, deliberative and creative, because it's saying rather than just proceed with changing the law because we've done a study and we think this will work best, that it ought to be more contemplative, that we ought to have essentially a venue in cooperation with regulators where the persons who would be regulated, as well as the consumers who would be affected by the regulation, will actually have essentially an experimental trial run with whatever those regulatory changes might envision. And so if it's suspending prosecution for unauthorized practice of law, or if it's abrogating fee splitting or partnerships with non-lawyers, then there would be what they call an entrant provider, say a tech company or a law firm, that would choose to enter the sandbox, and they would be giving the special dispensation. They wouldn't be prosecuted for UPL or fee splits. And so it would have to be hand in hand with regulators for a time period in order for this to work. But that you would be able to then assess whether or not greater access was created out of that entrant actually developed technology or new delivery methods that actually met the unmet need, and whether or not there was any harm that came of it. Was lawyers' independent professional judgment threatened by it? Was there other consumer protection issues that arose from it? And so you would have the entrants, the groups that would be regulated. You would have the changes or the suspension of the regulatory provisions, and then you would have the consumers who would benefit. And then you'd have that for, I suppose, a number of months or longer for a legal tech type of experiment. And then you would determine whether or not it needed to be changed to enhance it or improve it, that you had to go back to the drawing board, try something different, or if it's working, then I think the theory is, again, in consultation with the regulators, that it's something that could be made permanent. And so it was very interesting, and I was telling Justice Edmond in our prep meeting that it might behoove this task force, as part of its report, to the board, even though we're not the implementation body, we're really here to describe the concepts for reform that we think the board ought to consider. But we might have an ancillary recommendation that says, when the board considers implementing this, that the board also consider all the newest strategies and methodologies for making regulatory forms like these, that it not be perhaps the normal mode where we'll put out for public comment, we'll do a pilot program, and we'll see if it works. There might be a different way to approach this, and the board hopefully could be open to that and consider it, because I think there might be all sorts of options that are worthwhile. I don't know if we do a regulatory sandbox, but perhaps something like it. Any questions about the session?
I just wanted to say I think that's very similar to what they did in the UK with this SRA Innovate. And I got an email this morning from Crispin Passmore, which I'll forward to you all, talking about his program a little bit more, but he's the one that did this in the UK. And I just think it would be interesting to hear from him, his perspective about what worked and what didn't work with this sandbox type of model, and how it was helpful. So I just wanted to point that out.
Let me also mention that among the persons, I don't know if it was by invitation or it was just by outreach, but there were lawyers, at least one from California. There were some from other states, some from out of the country. There were online dispute resolution providers. There were legal services people in attendance. And it was interesting that when the session broke into its sort of think groups, that of the 5 groups that was busily writing up their proposals on the board, 3 of them actually focused more so on online dispute resolution as opposed to changes in the regulation of lawyers. Zeroing in on, I think, the idea that if you fix the dispute resolution model, then maybe there's less to do with lawyers if the consumers have access to a new dispute resolution model. But I think we were supposed to receive some sort of follow-up from the design lab about some of these proposals. So if I do get something further, I will share it with everybody. Also, Joshua Walker said that he knows Margaret and he'd probably be speaking with her offline, and he wanted to also, even though he wasn't able to attend, he wanted to address some of the thoughts that he has had about this and has been talking with Margaret about it the next time he's with us at the next meeting.
Okay, any other questions or comments? Randy, is that it?
The last thing I wanted to mention is that at your subcommittee breakout sessions at the end, there'll be discussions of assignments, and I'll try to touch base with each subcommittee about that. What we want to do is start launching the assignments for the draft report. And so we know that the recommendations themselves are still being formed, they're still evolving, but there are certain sections of the report that we can start drafting now for which we can make some assignments. For example, discussing the current regulatory framework for the practice of law, enforcement of authorized practice of law, the regulatory landscape with regard to artificial intelligence. I don't know if anybody's had a chance, but I took a quick look at the link to the Australia report that Professor Terry shared with Mark, and they have a whole section in their discussion piece about regulation of AI, which lays the groundwork for any sort of reform discussion. So I will be touching base with the subcommittees about assignments to help us get started on the report. And we only have one speaker this morning. We are hoping to have two, but the extra time that we have needs to be focused on the survey. That was the last item on the agenda, but if we can, we will bring that up a little bit early because our consultant, NORC, really needs our feedback coming out of this meeting as to the topics and questions and categories of data that they would like us to develop for our survey. So I'll be talking about that later. And we don't have a second speaker, but that time will be amply filled by just talking about our own survey.
Okay, before we launch we need to approve the action summary from the last meeting, the February 28, 2019 meeting. So if there's a motion.
So move.
Okay, it's been moved and seconded. Any edits anybody wants to propose? Hearing none, do we need to take a roll call vote, Mimi?
I think
Kevin. Professor Moore.
Who moved?
Toby did.
Toby moved.
Yeah.
Thank you.
I think so because at the last meeting, Simon wasn't here, so you can't assume his vote either way. So, okay.
Go ahead.
All right. Andrew Rita. To approve the action summary. Yes. Simon Bomey.
Yes.
Tara Bird. Yes. Judge Wendy Chang. Yes. Abhijit Chavan. Jean Clausen. Johan Trollshagen.
Yes.
Margie Estrada. Lori Gonzalez. Yes. Bridget Grammy. Yes. Andrew Kuchera. Yes. Joanna Mendoza. Yes. Kevin Moore. Yes. Heather Morris. Joyce Raby. Yes. Daniel Rice. Toby Rothschild.
Yes.
Alan Rodriguez. Yes. Dan Rubens. Yes. Mark Tuft. Yes. Joshua Walker. Thank you.
Okay, we're going to go ahead and get started. We are so pleased to have Professor Rebecca Sandifer with us today. I'm going to read her bio to you because first of all, she's incredibly accomplished, but also I think hearing about her background and knowing the experience that she brings will be helpful. So Professor Rebecca Sandifer is Associate Professor of Sociology and Law at the University of Illinois at Urbana-Champaign. My law school, by the way. She's also faculty fellow at the American Bar Foundation, where she founded and leads the foundation's Access to Justice Research Initiative. In 2013, she was the Hague Visiting Chair in the Rule of Law, affiliated with the Hague Institute for Internationalization of Law. In 2015, she was named Champion of Justice by the National Center for Access to Justice. Professor Sandifer's research focuses on inequality, particularly as it relates to law. Her scholarship includes investigations of work and inequality in the legal profession and other professional occupations, lawyers' pro bono service and its contributions to legal aid, and studies of ordinary people's experiences with common problems that could bring them into contact with the civil justice system. Her current research on the public includes the Community Needs and Services Study, called CNSS, a community-cited, multi-method study of ordinary people's experiences with civil justice problems and the resources available to assist them in handling those problems. The CNSS is funded by the National Science Foundation and the American Bar Foundation. Her current research on lawyers and legal services provision includes the Roles Beyond Lawyers project, a study of emerging models that use trained non-lawyers to provide services traditionally available only from lawyers. The Roles Beyond Lawyers project is conducted in collaboration with Thomas Clark of the National Center for States Courts, funded by the Public Welfare Foundation. Media outlets such as the Washington Post, ABA Journal, and Los Angeles Daily Journal have written about her work. She has made presentations on her research to state access to justice commissions, bar association groups, the National Conference of Bar Examiners, at the Department of Justice, to the White House Legal Aid Interagency Roundtable, and to the Ninth Circuit Judicial Conference. And I am so thrilled that she is now here to talk to us. Professor, welcome. Thank you very much for the time that you're taking to be with us today.
Thank you. It's a pleasure to be with you. Once upon a time, I lived in Sunnyvale, and I was on a committee of the Access to Justice Commission, the Right to Counsel Committee. And even in just the short time that I've been here and listened to you, California has come such a long way away from lawyers for everybody all the time. I mean, I think it's wonderful. I think this is a really big opportunity. So if California does something good, it helps a whole lot of people. But it also is a great model for the rest of the country. So I'm delighted that you're starting to work on this. I'm going to talk about 4 things. I'm just going to give a little reprise of what we know about how people think about their justice problems. I'm going to talk about the potentials for legal technologies to assist them. Those potentials right now are pretty much unrealized. And I'm going to show that by talking about the current landscape of technologies that exist. And then I want to talk about the insights that our research shows about how we could do things differently going forward to make these tools more effective than they are now. So one thing we know from my survey in a middle-sized city in the Midwest, from the LSC's 2017 survey, from subsequent research, is that there are hundreds of millions of civil justice problems that emerge in this country every year, and they affect every group. So in my survey, it was 2/3 of adults. In the Legal Services Corporation survey, it was 78% of adults had at least one problem come up in a year or 18 months. So lots and lots of problems, and they're not equally distributed. So people of color are more likely to encounter these problems. Women are more likely to encounter these problems. And of course, poor people are more likely to encounter these problems. The same collection of problems than people who are not poor. So all groups in society have these issues, but they're not equally distributed. The other thing that we know, and this is not just true in the United States, this is a global fact. The vast majority of justice problems that people have, you will never, ever see. You, as a member of the legal profession, as a judge, will never see these problems. So the legal system, even if we consider it really broadly, so all of the courts, all of the administrative hearing offices, all of the lawyers, they're at the top of a giant iceberg that sees maybe 15, 25% of people's problems, which implies that 85%, 3/4 of people's problems are not making it to you, are not making it to any formal legal thing. So you're in a place where it looks like this. The vast majority of people's issues are handled without recourse to the formal law. And once upon a time, we thought that this was because lawyers were incredibly expensive and court fees were too high. And those things may be true, but they're not the reason that people don't use law. And that insight is crucial in thinking about how to design technologies that would assist people. So if you ask people, hey, you've told me that your employer's not paying you overtime. That's called wage theft, but they don't have to recognize that it's called wage theft, right? It's just a fact about their lives. Or you're 2 or more months behind on your rent, which means you're at risk of eviction, but they don't have to know that. It's just a fact about their lives. If you say, okay, let's go through these 95 different specific problems around employment, around housing, around benefits, around your neighbors, around your family. You've told me you had this specific problem, your employer's not paying you overtime. What kind of problem is that? Is it a personal problem? Is it a moral problem? Is it a bureaucratic problem? Is it a criminal problem? Is it a legal problem? Is it bad luck? Is it God's will for you? The most common way that people will describe their justiciable civil legal problems is as bad luck or part of God's plan for them. Now, if I think this is just something that happens to me, or even more, if I think it's supposed to be happening to me, I am not going to go file a lawsuit about it. I am not going to go see an attorney about what to do about this situation. I'm not thinking about this in a legal frame at all. That's a key insight if you're thinking about how to design interventions that will meet people where they are, because that's what these new interventions will have to do. There's another chunk of justice problems that people describe in a way that suggests that they are not interested in third-party intervention into that problem. So these are our problems. They're my family's problems. They're a private problem. They're a community problem. Someone's going to solve this problem, but it's going to be us. It's not going to be third parties who are outside. And then there's a tiny proportion of justiciable events that people actually understand to be legal. So any kind of intervention that we all come up with has to recognize this fact about how people understand their justice problems and recognize the fact that the vast majority of these things are not making it to courts. And by the way, we don't want them to, right? So if you leave out traffic, there are an estimated 25 million civil cases in state courts in this country every year. Okay, there's an estimated 150 million civil justice problems happening every year. There's no way we would want all that stuff to go through courts or any kind of formal legal process. So what are the ways we can assist people with those problems that don't bring them all into court? People don't go to law. They typically try to handle things on their own. They occasionally do nothing. When they reach out to third parties for assistance, the first place they go is their immediate social network. They go to family and friends, and they get their ideas about what to do. There is about a quarter of problems that people take to a third party. That third party is usually not an attorney. So people go to religious leaders. People go to community organizations. People go to membership organizations. People go to elected officials. People go to, if they are in something that provides them an ombudsman, they'll go to that person. They're very creative in how they reach. But a lot of their reaching is not to law. And part of the reason that they're so likely to either rely on themselves or their friends is the way they understand about their problem. So if you say to somebody, okay, you've told me you had this concrete event in your life that is justiciable, but you didn't go to anybody outside your immediate social network for help, why not? What you see is that cost explains less than a fifth of the instances in which people do not seek help. Right? So it may be really expensive, but that's not how people are thinking. Sometimes people don't know what to do. Sometimes they're stressed out. But the most common reasons people give for not seeking help for a justice problem are that they got this one, right? I don't need advice. I understand this situation. I know what to do. There's another version of that that's a little bit more fatalistic. It wouldn't make any difference, which still implies that I understand the situation and I know what to do, and what to do is nothing. And the challenge is that sometimes these people are absolutely right. And we should, acknowledge that. But sometimes they're disastrously wrong. And so finding a way to catch people who are making what we wouldn't want them, a decision we, the people, would not want them to make, is the real challenge in thinking about how to design these kinds of interventions. Okay, so that's the way people think about their justice problems and some of the challenges it presents to us if we want to think about how to help them. Now, there's an enormous amount of hype about how technology can solve every problem that every person has in this society right now. And there are a couple of reasons that you see it in the legal space. So one is, once upon a time, there were all these human beings, we called them lawyers, and they did all this stuff that was called legal work. And particularly if you look in the big law space, many of them have been replaced by robots, right? So once you have a word processing program that can look for a word in a whole big pile of documents, you don't need 5 associates to look for that word in a whole big pile of documents. So there is some of this stuff that can be automated, and I think there is a certain fear in the bar about being replaced by robots. There's another side to the hype, which has to do with the services people might receive that they're not receiving now if we use technology. And so one approach to that is that, the nice thing about technology, if you're lucky, is that it's very efficiently scalable. So you can provide that same service to lots and lots of people, or that same opportunity to lots and lots of people at a lower price. The other thing that people are excited about legal technologies for is let's imagine what a legal technology does is it takes part of the expertise or the ability to use the justice system that used to be held only by fully qualified professionals, and it distributes it out. So it gives it to people in communities so that they have that knowledge or that capacity. They're now empowered in a way that they weren't before. So that's another reason that people are excited about the possibilities of these tools. We're not achieving much of this right now. All of you are still human beings. You have not been placed by robots. And most of the tools that exist right now are neither efficiently scalable nor legally empowering. But there's no reason it has to stay that way. One way to think about these tools and what they do is to think about them, as I said just a moment ago, as taking pieces of legal expertise and legal capacity and distributing them. So if you think about what a lawyer can do in our system, a lawyer can represent you. So that lawyer can speak on your behalf and act as you, whether in a formal legal setting or with the other side. That lawyer can enact things on your behalf. He or she can file motions, make statements, do stuff like that. That person can give you legal advice. This turns out to be an important linchpin here, and I'm delighted that you all are thinking about this. So legal advice is the ability, as you all know, to say, okay, from the messy facts of your life, here are the legally actionable issues, and here's what I think you should do about them. Lawyers have privilege, so you all know this too. So information that goes back and forth between lawyers and their clients can stay inside that relationship. It's protected. Anybody in this country can give legal information. That is, they can tell you what the law says. And the other thing about lawyers, at least in our system, is that once you are qualified and you're in the bar, you are omnicompetent. You may not feel omnicompetent, but you can practice in any area of law, in any forum where you're listed on the rolls. Okay, so if that's what a lawyer does, it's a long time before we're going to have robot lawyer. I mean, that is an enormous set of capacities, a tremendous amount of information. We're very, very far from that. But what you do see is different kinds of tools that pull off smaller bits of this, usually in just 1 or 15 areas of law. So the most widespread tool for low-income people in the United States, every state has a statewide legal aid website. And most of them have all kinds of articles that were written in the 80s and 90s by third parties, digitized and put up on the web. And so if you want to know about, I don't know, how to get your security deposit back, you have to read a 25-screen article about landlord-tenant law. That usually is written at a reading level that's too high for most people in this country who have less than a high school degree. You might also be able to fill out a form. Sometimes you have to print the form out and use a pen, but there are some, if states can get it together, and this turns out to be a big issue, if states can get it together to agree that there's one form to do something and it must be accepted by every court, then you can put that form on that website and people can try to execute it themselves. So there are many, many things in this space, in the form space and the information space. What you see much less of are tools that actually would help the vast majority of people who don't know their problem is legal. So look at what that says, Montana Law Help. Okay, so I'm going to go there if I think I have a legal problem or I want a lawyer. But what about the 90-some-odd% of cases where I don't think that's true? So sort of the way this stuff is fronted makes a big difference. So in the middle here is something that, please don't sue these people because I love them. But once I describe what they do, you're going to see they're kind of giving legal advice. Maybe they're not, I don't know. But this is a tool called Just Fix, and this is a woman who's holding up her cell phone and she has a picture of a dead rat. And what Just Fix does is it says, are there some problems with your apartment that you would like your landlord to just fix? Let's go through a little, very simple interview. Is there mold in the bathroom? Are there rats? Are there cockroaches? Does the elevator work? Do the common spaces leak? Whatever. You go through the whole thing, you press next, and it says, okay, you told me there was mold in the bathroom, go take a picture of it with your cell phone. You told me there were rats, go take a picture of them with your cell phone. Then you press done, and it writes a letter to your landlord that says, dear landlord, I live at this property. I am your tenant. I would like to tell you that under New York City housing codes, you are violating the following things, and you must fix XYZ. You have this many days to do it. You've got to give me 72 hours before you enter into my apartment. And by the way, appendices A through K are the date stamped, time stamped, geolocation stamped photos from my phone of these violations. And then this organization will send that certified letter to your landlord. You don't have to know you have a legal problem. You don't have to know you have any rights. You just have to know that there's some crappy situation that you want fixed. So there are very few things like this. But obviously there's a lot of potential here to work on specific problems in a focused way. So we did a by locking undergraduates in a windowless room and making them search Google Play and iTunes, and by looking at venture capital lists and all kinds of things, we tried to identify as many of these tools as we could. And we found 322, and then after I released the report about on them, 8 people wrote me and said, "You missed my tool." So there's like 335. And they do a vast number of things. So there are things like LegalZoom, which are both smart document preparation, but also a platform for unbundled legal services. There are, I don't know how these things exist. There are 1 million lawyer referral services. No one uses them. No one used lawyer referral services when they involved the phone. No one uses lawyer referral services when they're on the internet. But I guess it's sort of a cheap, easy thing to set up. So there are many, many of those. Legal Match is one of them. And then there are a range of them that help you work on some kind of specific problem. So Simple Citizen lets you figure out if you are eligible for certain kinds of status regularization under federal immigration law, which makes things much more scalable because it's federal. It helps you do the documents. I think Simple Citizen you pay for. So there are about 30% of these that are either pay for service or freemium, as they call it. There are several that do immigration. There are several for tickets of different kinds. So with Fixed, you take a picture of your ticket, that program works on it, and then you pay them a contingency fee of what you save by getting the ticket adjusted or forgiven. There are a range of them in the criminal space as well, and I put up this one because I like whimsy. This is the Oh Crap app. But it also illustrates the fact that this is an entirely unregulated space, and so who knows whether the Oh Crap app is good for you or not. So the Oh Crap app will text your mom that you've been arrested, connect you with a bail bonds person, connect you with a lawyer, and will sell you arrest insurance. Never heard of it before, but apparently it's a product, and you can buy it from this app. So many different kinds of things happening. Some of them are probably totally credible. Some of them are maybe not credible. There's not really an easy way for consumers to tell the difference between those things right now, which is another thing to think about in this space. The problem with all of these tools is that most of what they offer is not what people want or need. Most of what they offer is what providers already have, right? Which is information, right? So remember, nobody thinks their legal problems are legal, so they're not out there looking for legal help. 91% of justice problems, at least in my survey, people don't recognize legal aspects. There are very few tools that help you identify the fact that you have an actionable problem and take some action on it. Most of them assume that you've already figured out that your thing is legal. So the vast majority of these things provide legal information about your legal problem that you already understand is legal, or they will connect you to lawyers to assist you with your legal problem that you already understand is legal, or they'll help you make a legal document for your legal problem that you already understand is legal. There are a few that will help you sort of compile evidence, but typically it's for something that you realize is a claim, right? Otherwise, why are you doing it? There are very few of them that actually help you diagnose that problem as actionable. Like, I have a problem, I could do something about it. Maybe it's a legal solution, maybe it's not a legal solution. That's where the possibility space is here. That's where the wedge is to get in. There are some other issues with these technologies if you're thinking about them as things that would be used by consumers rather than by intermediaries. So most Americans have access to the internet, although some don't. Some have no private access to the internet. But many people's access to the internet is smartphone dependent, which means there are data issues and cost issues. And the folks who are most likely to be smartphone dependent are the same people we're trying to target with legal aid. So folks who are low income, folks who have less education. So maybe we're designing tools that are really good for middle class people, but are not maybe matching the needs of the actual population we're trying to help. So besides the technology excluding people at this particular time, these tools are designed in ways that make them less likely to be accessible to a legal aid population. Only about 25% of them present whatever they offer in a language other than English. If it's presented in a language other than English, it's usually Spanish, a place where you'd see a difference. New York, California, you might see 5 languages, 8 languages, because they're more diverse, bigger, wealthier states, but usually it's English or English and Spanish. And then all of these things, almost all these things are really heavily text-based. And so being very text-based creates barriers for two different groups of people. First of all, people who can't see text to read it, but then the 1 in 6 Americans who basically don't have enough literacy to read a newspaper cannot use these tools, and they are going to be disproportionately concentrated in the legal aid population. So a lot of promise here, but not really being realized. The other thing that's really interesting about these tools is even the extremely cool ones, JustFix is an extremely cool tool, adoption rates are really quite low. It's very challenging to get people to use these things as we are currently rolling them out and implementing them. So how could we make this more useful? Well, one of the things that you'll hear more about as you learn from Margaret Hagan and her colleagues at the Design Lab is when the internet started in the 90s, a whole bunch of words, like a wiki, seemed really cool, and it made sense to all of us. But all of that has moved forward, and so consumers' expectations about what a website is going to be like or what a web tool is going to be like have changed. What Margaret Hagan is doing is working with the communities that would use the tools to do user-centered design. Most of these tools were not designed with user-centered design, and so that has got to be part of the next step. The other thing, and this I've found is true, part of this is an age issue, but part of it is not. There are many of these tools where people might use them if you give them a human intermediary. They would leverage the capacities of the human intermediary, but people are not going to use them by themselves because they don't trust them, because they're not comfortable with computers, because they have low literacy levels, whatever. So finding ways to pair them with people will make them more used and useful. There are also kind of financial issues here. So, you know, the reason that statewide legal aid websites are so bad is because they were designed in the 90s and none of those organizations have the money to update them. And you do actually have to keep making sure that these things work, that your links aren't broken, that that as people's expectations change, your product and service change, and that costs money. And the way we fund this stuff right now, we say, that's a great idea, and then we leave them alone. So thinking about a way to make that kind of funding more sustainable, I think, is key. The other thing is that we think all this stuff is going to scale really easily, and sometimes it does. So immigration law is federal. We know there are massive differences in how legal professions in different parts of the country work. You know, there are arbitrary distinctions between judges and the number of things that they approve or don't approve, but at least the law on the books for immigration is the same throughout the country. But there are 3,000 some odd counties, and every one of them may have its own its own housing code or its own whatever. And so scaling from California, from Sacramento to San Francisco for a range of issues is actually not a straightforward thing to do. So thinking about that makes this more expensive and time-consuming and challenging than it sort of seems at first. And then finally, so if you imagine the kinds of things that Margaret's trying to do or what Robot Lawyer would do, so part of that is the interface out being very accessible and engaging, but part of it is that behind that interface, actual human beings and organizations are coordinated in a very sleek way. It turns out it's really hard to get state courts to behave. So in more than one state in this country, when I do this research, they will say, some group will say, we got the state Supreme Court to agree that this is the form to respond to your eviction, or this is the way you change your name, or whatever. And then they'll say, you know, and then we put it in our tool, and then e-filing is its own problem, but we put it in our tool. But when they print it out and take it to the clerk just says, no, I'm sorry, we only use the pink ones with the staples in the middle on the right side. Now, that's a cultural issue about American courts and how state courts and how they work. And so thinking about how to change that, which would have to be done in each specific location, is important. An important opportunity for making these tools much more effective than they are now, because the person has to be able to execute the thing that you've allowed them to do, and getting the state courts to participate in that is essential. And then finally, and this is why I was so happy to hear the first conversation that you all were having today, right now, the reason most of these tools are terrible is because there are deep concerns in the community of developers that you're going to go after them if they create a tool like JustFix that does something useful, because it's nudging up against the edge of legal advice. And so thinking about either one of two things is happening. Either the way that community understands legal advice is wrong, right? It's more restrictive than it actually is, which is a possibility. Or the other possibility is that it's too restrictive. And so then if the UPL restrictions on legal advice are too tight, what's the smart way? What's the evidence-based, careful, deliberative way to relax those restrictions so that these things can be useful as well as used? Thank you.
Questions,
Yeah.
comments?
I also want to support something that you're saying about the cultural change of courts and clerks, is that there's also a financial incentive sometimes to, if you have a clerk, for example, who sells forms, they're not very happy if you automate those. And so what we have found sometimes in the state that I work in, where we have created county-specific and county-compliant document assembly tools that are being rejected by the clerk because the clerk doesn't want to recognize, the clerk sells those forms and can tell that it's not coming from them. And so even though we are compliant with the statutory and regulatory language, that it have the staple on the left-hand side and that it, it do all the things that the thing is supposed to do, they figured out that it's being done by somebody else. And what they really want is for everybody to come in and pay $25 for their form packets. And so, I mean, it's more than just culture. There's also financial disincentives for this stuff to be allowed to work.
Andrew?
I also think one of the things that were identified that was particularly helpful was the gap between people's understanding if their problem is legal or not, and how we would go about kind of letting them know that there is something available. And one of the challenges, this is more of a comment than a question, is I do find, at least myself, growing up in a community that also was low economic kind of background, et cetera, a lot of the time what scares people away from going to lawyers is their perceived cost of the services, and therefore it's almost like we have a chicken and an egg problem with that particular issue. And I don't have any kind of proposals on how to solve it, but just something that I think as a task force we do need to be very mindful of is how do we even get folks to be willing to kind of engage with the legal system to begin with. And it was something that I think was very important to bring up.
Lori?
I wanted to ask you a question because what I found most surprising in your report was the idea that people don't know they have a legal problem. So it's actually not the cost that's the majority of the issue, but that people don't identify their problems as legal. Do you have a thought on what one thing we could do in legal to help people identify their problems as legal more or get the help they need? That's my first question. And my second question is, do you think that legal needs to be the one driving that? If people don't know their legal problems, who's best situated to help them maneuver those problems?
So one thing that we know about the way adults think and learn is that we're all adults here, right? We're really bad at taking abstract information we learned 25 years ago and applying it to a concrete situation that we're in. So the kinds of educational or informational interventions that work are those that catch you when you realize you have a situation and are targeted to your situation. There aren't, it's one of the ways that different programs try to do that now is by embedding the legal service in some other place where people already go. So you probably heard about medical legal partnerships. This is when you have a community health clinic or a hospital, and they'll partner with a legal aid lawyer or a law school clinic. And the idea is sometimes there are health problems that have a legal dimension. The marquee example would be asthma. So lots of kids who live in urban environments have frequent asthma attacks, and one of the things that creates those asthma attacks is cockroach feces. Well, that's a violation of a housing code. It's a pest infestation. And so if the lawyer can get the landlord to stop that, you can actually improve the child's health, like their experience of daily life. So there are some that try to place them in churches and other kinds of religious organizations. There are some that try to put it in schools, but that's one. So co-location is one way to do it. Another thing that I haven't seen anyone try yet, but I wonder if it would work, is let's say for the next 7 years, the state of California said, we're going to have a legal education campaign that's going to go like this. What are the problems that we are worried about that people have that they could take action on? So when I think about this moment in history, wage theft, right? Because that we want people to get paid what they're owed. There are lots and lots of kids in this country whose parents, for a range of reasons, cannot take care of them, and there are often other people who can, but those other people don't understand. You can't just like take your grandchild home and then drop her off at school, right? You have to have some kinds of legal documents that let you get her health care and enroll her and get her vaccinated and all those kinds of things. So could you imagine every year, 18 months, there's a campaign about a specific issue, wage theft, guardianship, whatever it might be. And so then that's going to catch the people who are having that experience right now. So that's some chunk of people who will now be sensitized to a legal issue. But, you know, maybe it's not happening to me right now, but 2 years from now when it happens to me, my cousin's like, you know, I saw this commercial that said. I think I'll give an anecdote about why that this can work. So I was doing focus groups before I did that survey to sort of try to figure out how people think about their justice problems. And I had them look at hypothetical scenarios, like Mary's 2 months behind on her rent. What should she do? People are totally unaware of what they could do. But more than once, someone would say, I don't know what she should do about age discrimination, wage theft, this potential eviction. But if she had been injured in an accident, she could call and they would give you the name of the law firm that was on TV all the time. And so I think that the genius of that is it tells you you have a problem, it tells you you can act on that problem, and it tells you where to go to act. So some kinds of very focused, targeted programs like that, which could be on TV, they could be community embedded, whatever, I think would go a long way in sensitizing people to their rights, essentially.
Mm-hmm. So follow-up question. Then I think of personal injury as well, how well that they reach the consumer. But there is money in personal injury. We all of those that support law really like to get hired by personal injury attorneys because they have money and they spend money, unlike some of our other lawyer friends. So that then raises the question, you know, I am a fan of, I love to follow the rules. Although on this committee, I am the one proposing we break and do away with all the rules. Because the reality is there isn't money in the legal field to do all of this as it stands today. So how do we find that money? What are your suggestions? Because I love the idea of commingling relationships. We have a great partnership in Tennessee with our Access to Justice groups and very faith-based partnerships where we are doing legal clinics in churches. But I'd love to see us take it to a next level. What if those churches were then empowered to provide legal forms and legal advice in very specific areas? Because that's where people go and look for help in Tennessee. That's our entire social network. So my question is to you, how do we get the funding? Where do we get that from? Is that in legal? What's our next step?
I think besides doing all the usual things, right? Foundations, government, blah, blah, blah. I think there are two things I would love to see the access to justice space in America explore. One of them is, can some of the people who receive this stuff pay something for it and thereby subsidize the people who cannot afford to pay anything for it? There are a lot of people at 126% of poverty, or if you're in a place that's really generous, 201% of poverty, who can't access the free service, but could pay a little bit for the not free service. And that lets you cross-subsidize. I think another thing to think about is Big Law donates an enormous amount of time in the form of pro bono hours because it's in that ranking. And it lets them tell their associates a story about how they're not just helping rich people stay rich, right? They're doing something. They're being real lawyers. What if, instead of just donating that time, they did what Legal Aid has wanted them to do forever, which is just give us the money? Right? Like, so give us the value of that time, the market value of that associate's time, that bank of associates' time. And that would fund a lot of these things. That would be a massive amount of money. So then you have to think about how do you create the incentive structure so that they have some reason to do that? Is the tax write-off good enough? I don't even know if you can write that off your taxes anymore. Probably, given the recent tax reform. But, would you have to work with US News to change the way they calculate the social benefit issue? Or would you have to create a new index that's, rewards them for doing that? I don't know, but they would need some kind of incentive to change that behavior. But if they did, that's a lot of money.
Question. One of your slides where you showed that there's sort of a disproportionate impact, that the need for civil legal services is great, but it's disproportionately impacting certain communities. I thought that on your income chart, there were still like over 50% of middle income and high income folks with unmet civil legal service needs, or with civil legal service
They just have problems. We don't know whether they need legal services or not, but we know they have problems.
They have problems. So one of the things that I keep wondering about as I learn more about the issues we're sitting here is how far up the income ladder the justice gap actually goes, meaning that gap between the problem or the need and your ability to actually hire a lawyer to provide the service. And therefore, is there a whole population now that's not getting any service at all that could pay for it? Not just the folks at 126% or 201%, but the folks at 300% and 400%, because an actual traditional lawyer at an hourly rate is very, very expensive for many people. So is there a market there that could essentially fund or subsidize services that would be provided to the truly low income? That's, what I think there is a business model here. There's money to be made. And so I just keep wondering about that.
I think you're absolutely right. And as an observer of the American legal profession, I'm always baffled at the lack of entrepreneurship in the personal client bar. Right? So unbundling is a possibility in every state in this country now, but very few lawyers do it. But unbundling is exactly what makes legal services affordable and sensible to a middle income person. Right? I'm going to do this for you, this for you, this for you, and it's going to cost this much. Why not? I mean, I don't know why there are very few lawyers operating on that business model, but there are. I mean, when I ask them, they say, well, I'll go in and the judge will make me, represent this, and I'll lose I'll lose a bunch of money by doing this unbundled thing. But I don't know that there's any empirical evidence that happens a lot.
I just wanted to throw out, there is a survey that I was provided with early on in my entrepreneurship of starting a company. So I went from working in law firms to starting a business that supports lawyers. And I had a lawyer turned real entrepreneur, which I think, meaning he's went into some crazy places, provide me a survey that was the most informative for me in creating my business. And I think I'm going to share that with the group. But I think there's an answer to that idea of why lawyers don't do it. One of the study identified 6 places where lawyers are abnormally different than the average person. And it's just fun reading, so I'm going to share it. But one of the places is, so autonomy is a big one, very high autonomy, which means not working with groups. So why haven't we created, better relationships? As a profession, lawyers are actually much more autonomous and don't collaborate well. But it's the risk adverse. If you are risk adverse, and we actually were talking about this earlier, as an entrepreneur who works for lawyers, I joke all the time, I'm the least scared of getting sued. I should be terrified of that. I have zero concerns. Not zero, but very few. And that lets me do things and push boundaries that most of the lawyers I work with would never consider because they are risk adverse as a personality. And so I'd like to encourage our group to maybe think about, as we are creating our suggestions, remembering the group that we're dealing with. If we continue to allow lawyers to be the one pushing the innovation, we are actually asking a group of people who, by personality, are abnormally adverse to risk, which is the opposite of what you need to be an entrepreneur or to push innovation. And so I think there is an answer to that.
I'm wondering, given our position in California and our location close to Google and Facebook and those platforms, if we should be working with them when somebody types in a Google search asking about their problem, rather than have a law firm's article come up, have an app that we agree would be helpful to someone with that problem come up on the search engine. Same with Facebook. As we know, you'll type anything to anybody out there, and all of a sudden the advertisements coming up are related to whatever it was you were looking at. If there was a way to work with them to help in this area to kind of bring the ideas to the people that are having the issues, we're in a great location to be looking at that.
And Margaret Hagan actually is one of the bazillion things she's doing is a project called Learned Hands. It's a little joke. And so what Learned Hands does is it takes the queries that people write on Reddit about justice problems, and then it crowdsources issue spotting from lawyers and law students. And then that would then be the data that would train AI to do exactly the kind of query sorting that you're describing. I mean, it started 2 weeks ago, right? A month and a half ago, and so it's very early days. But you're, I think you're absolutely right. There's a lot of potential there.
Bridget?
I wanted to ask you about whether you have seen lawyers collaborating with other professions. So when you were talking about the child with asthma or people recognizing that they need guardianship documents, I could envision working with physicians to train them, if they see these particular symptoms, to ask families about these issues, or same with social workers, for example, with the guardianship. So I was just wondering if you've seen any models of multidisciplinary focus on these issues.
Besides the medical legal partnerships, which are kind of the big one, there are 300 some odd of them around the country. There are a few social worker programs. There's also, I think it's here in San Francisco and Denver and a few other places, social workers in libraries. So many people who don't have homes spend time and take care of basic life functions in libraries. And that becomes an issue for the libraries and the other patrons. And so now there are social workers in a range of cities who do outreach to those folks to help them connect to various kinds of benefits and services that they can't connect to. And a lot of those are basically justice problems. Like if I'm a veteran and I can't get my benefits application through, it's that. So I think there's a lot of potential there. The thing is to think about where people already go.
Simon and Andrew.
Just a quick comment. In terms of it wouldn't be feasible necessarily to have that occur via kind of the Google example. The challenge that we have is that it would actually take quite a lot of money from a kind of SEO word ranking to do that. So I think the way that we may want to think about things is not necessarily that the State Bar pushes the tools, but creates an environment where the economics and the benefits that may accrue to companies that are building these tools, that we make access to justice make business sense. And I think we all seem to agree that there is something there, but I think that that's the framework we should be thinking in, because it won't be possible for us to compete to kind of push that as a group or as a task force.
Thank you so much for your presentation. I really enjoyed it. One thing I'm curious if you could comment on, whether through the research or through your own shared experiences, is mobile versus desktop. And when we talk about access to justice or thinking about technology, oftentimes we assume everyone has a laptop or people have an iPad, right? But oftentimes someone has to go to a public library. But in the same vein, there's over 240 million smartphones in the United States alone. Of course, there's a gap within that as well. People who can afford to have a smartphone, those who can't. And particularly among generation lines, my iPhone is my remote control for my life. And oftentimes I expect every single website I visit to have some sort of mobile-friendly option. But just getting a court to agree to create a website is a victory in itself. And to have it mobile-friendly is even a larger victory oftentimes. So I'm just curious if you will see some of that coming and maybe just look into the future and share with us the importance of making sure that we don't just offer technology, but we offer technology that actually meets customers and consumers at their convenience.
I think you're absolutely right. And I think if courts are staid and conservative institutions, And as you say, even letting them have a website where you can get the change of name form or whatever is a big deal. I think what may push courts to be a little bit more mobile friendly, and if they were here, there must be some here, they would complain about how it's expensive. Then that's you have to find the funding for that. But many courts are excited about the idea of taking some disputes entirely online. And in order to do that and make it effective, whatever interface people have is going to have to be mobile friendly, because you can't expect everyone to go to the library and participate in their debt collection lawsuit asynchronously on 15 different occasions. I mean, it sort of obviates all the good that the consumer would get from that. So that, I think, is probably, that shift may push courts a little bit.
I just had a relative, I hope to be a quick question. Your last point in your last slide has been sticking with me, and it said the restrictions on legal advice by non-lawyers means tools can't do much without running into the unauthorized practice of law. And then you pose the question to us, which is to look at whether the UPL restrictions are too tight. And I would assume you would think that they are. And I was just curious, and then you also asked us, what careful, deliberative way to relax those restrictions might we consider to allow these tools to be used. I was just curious if you had given thought to what restrictions, what relaxation of restrictions might be envisioned, and what guidance you might give to our group as we consider that very difficult issue.
So, from my perspective, the only reason to have restrictions on the unauthorized practice of law is consumer protection. But it's not my monopoly, right? So, but if the issue is consumer protection, then what matters is creating an environment where people can tell that there are bad lawyers, there are bad providers of every kind, but where people have some ability to tell the difference between credible and not credible sources of support. So in the United Kingdom, the way they do this is there are no restrictions on giving legal advice. Anyone can give legal advice. But at the same time, there are established advice providers that are signposted as trustworthy, like the Citizens Advice Bureau, and all kinds of different sort of group and issue-focused organizations that you can go to for help with your housing problem, with issues around aging, with issues around being a child, whatever. So I would be fine with getting rid of all the restrictions on advice. If there were something done to create an ecology where there's some kind of signposting to consumers about which of this advice I could believe and which I couldn't believe. I don't think, the space of tools is a little bit concerning right now, because let's say I'm a low-income person who gets arrested and I go to the Oh Crap app and I buy arrest insurance. I can't imagine that arrest insurance is a good product, but maybe it is. So now I've lost money to pay for the insurance, and then it may cause me other problems that I have to then do further work to solve. What's a way to, I don't think we want to regulate that space, but what's a way to market, quality check it or something? I don't think that the bar can do all of this. I think that it's, to go back to the point about connection, there need to be collaborations across lines of activity that would help you all. The restrictions on UPL are there for some good reasons. Would help you all work with other entities to retain those good reasons, which are, as I say, I think about consumer protection, but then some of this is just excessive.
If I may, you're all going to get an email later today. I actually sent it to Lauren. I think she's sending it to you now. The good news is we've solved all these problems. The marketing platform is called Master Blaster. I developed it 2 years ago. It does exactly what you're looking for. The website platform that you're looking for is called Quantum Website, and we actually function in 58,000 jurisdictions across the country. And on the first article I sent, I think I actually used your same image of the iceberg. So I absolutely love that. We've had a lot of success down in LA, working with local organizations and trying to take them to scale by giving them a cloud-based platform. And in this type of scenario, if the court's involved and can actually sort of ratify the workflow and then distribute that throughout the entire state, available to be branded by each individual organization that needs it, whether it's a jurisdiction or a court or whatever the case may be. It creates some solidity to the flow. It actually removes the need for a sandbox because it can be adjusted as the progress is made, and it communicates outwardly to the community when something comes about. Matter of fact, after the last meeting, a couple of us had a conversation about solving the Notorious challenge, and one of the things that I proposed was actually for the bar, is that you can actually use an urban legend to shut down certain criminal behaviors, similar to the way in 1985 Washington, D.C. Offered football tickets and then rounded up 100 outstanding felon warrants. And now nobody's going to respond to that letter because they're anticipating the arrests at the other end. And that type of thing could be very, very useful, and that type of marketing can be useful. But it actually, in both cases, is able to actually feed Google the information they need, and then it adds in manipulated metadata to identify a particular article or marketing campaign to an individual location. So we add all the physical locations from neighborhoods up throughout the state of California, and that article will be repeated for each individual location throughout the state. And I've got pitch decks that are part of this email as a link for everybody to go ahead and take a look at those as well. I didn't want to do a full-fledged presentation, but I agree with everything you're saying, and we've got the tools, and they're ready to launch, and thank you for validating all this. The numbers were great. Appreciate it.
I never go anywhere where someone says we've solved all these problems. It's awesome.
Toby.
You were talking about the medical legal partnerships, and I've been involved with one of those, and it really works well. The doctors are advised and trained on how to identify health issues that might have a legal consequence or a legal causation, referred to the lawyer. And we've done the same thing with social workers, with the welfare department, and trained them to find the right people. The biggest problem comes in that because of the rules, the doctor wants feedback. And it's once the client talks to you, it's confidential information. And there's issues about how do we work together as opposed to, and sometimes it's not that they need the feedback because it'll help the client with the legal problem, so it doesn't fit under the exception to attorney-client privilege. It's just that they want to know and get feedback on how they can do better and all those kind of things. And there become problems in providing that kind of input.
Anybody else? Randy.
Professor, it did strike me that there are a number of tools that are already out there, and some actually might be effective, like the Fix-It, but there was such a strong amount of low adoption, I guess, by consumers. Would any sort of state bar or regulator imprimatur help with the outreach to get adoption of these tools? So if there was a state bar approved app, or if there was a provider that was state bar certified, do you think that would make a difference at all?
I think it would make a difference with the intermediaries, right? So the community organizations or whoever that might be the real way that you roll these things out. Unless you have a massive advertising budget, which, I suppose we could imagine a world where that's true, but I do think, especially in a space where it's the Wild West, and some of this is real credible activity and some of it's not, to have an official entity that knows, say, we trust this one. You don't have to say anything about the ones you don't trust. I think that'd be very valuable for consumers.
The other thing I noted was that the sustainability of innovation requires capital. Do you think, as a essential proposition, that there has to be some element of non-lawyer ownership or shared equity among entrepreneurs and lawyers in order for the legal tech space to really thrive and continue?
So your former California resident, Jillian Hatfield, would say yes. I think that's not essential, but it also won't work unless there's also a space that's a for-profit space, right? Non-lawyer entrepreneurs are not going to invest in a free service. So then there has to be a way to think about, can we have can we have services where people who cannot afford to pay are subsidized by people who can pay? And then I think it doesn't matter. I'm untroubled by non-lawyer ownership. I think it's an empirical question whether it expands the capacity of these organizations or makes them more creative. So when the UK moved to non-lawyer ownership in 2008, do I have that right? I'm looking at you because I feel like you would know. I think it was 2008 with the LASPO law. They then set up a little office that was sort of trying to study the effect of that on access to justice. And so far, the jury is still out on whether it makes services cheaper or more accessible or whatever. I mean, it may just take a while.
One last question. There's a lot of literature about how legal tech has all this promise, but it's also not the silver bullet. Is it your opinion that there has to be some other innovation in delivering legal services other than tech in order to meet the access crisis? You have the limited legal technicians and all those other things that are happening.
I would say if you were going to put three things together, they would be technology, which needs to be empowered to let people do things that are actually useful. They would be different kinds of service providers who do some of what a lawyer does, but not all. And they're going to need to be able to charge for their services, which is where if they're not charging, no one cares, right? And then the third thing is, and this is problem by problem, there are areas where access to justice is caused by the failure of justice institutions to apply rules they already have. So an example would be consumer debt collection. Many lawsuits in many states have been filed without adequate documentation to show that that respondent owes that money. When courts impose a rule that says not even you have to show us the documentation, but you have to attest under penalty of bad things that you have the documentation, the filings drop dramatically. Now, are there other areas where we can just take the rules we already have and apply them so that people aren't put in the position of having fake justice problems, in a sense? So I think those three things would be the big innovations.
I have a question. I'm not sure, Professor, how much longer you're going to be with us today, and so I want to sort of incorporate you a little bit into what would be the next topic of discussion. We're going to be engaging in a survey to the broad population. So we want tech companies to respond to the survey, and we want individuals in rural communities to respond to the survey. And as a matter of fact, the current thinking is that we would be oversampling rural communities and oversampling people at 125% of poverty or less. So now you know more about the survey than everybody else in the room. Because we want to make sure that we are not just sitting in a room in an ivory tower coming up with recommendations to improve access that nobody's going to take advantage of, right? Like you said, we've got all these tools out there that people aren't taking advantage of. Though I have to say, looking at your list, I am a little baffled by Knife Rights Legal that compiles the knife laws of all 50 states, but that's just me. So if you were drafting this survey to figure out what we could do in the digital world, in the technology world to improve access, what are the key things that you would say we should be asking to the rural communities, the low-income populations, and to the tech companies to make sure that we're putting something together that makes sense?
That's a great question. I think when you do this survey, you probably have a couple of goals. So one is to understand stuff, and the other is to tell a story about California that's legible to the people who you need to move. And so you're probably going to end up asking a lot of questions we already know the answer to, right? Which is fine. I mean, that's what you have to do in a place where politics are very local. I mean, you're going to find that a lot of people have problems, that very few of them go to law, that they happen in core areas of life around housing, taking care of your family, livelihood, whether that's your pension or your benefits or your wages. You're going to find that if you ask people how they think about their problems, you're going to find that they don't think about them in legal terms, because we find that everywhere, all around the world, when we do these surveys. You're also going to find probably that the people who have most access to law are wealthy people and poor people. And then there's sometimes they call it a sandwich group that's in the middle. But then thinking about what it would be cool to know that would help you design a better world, I think you want to know in some kind of detail where people go when they're having different, either where they go just socially or where they go when they're in trouble. I think from the tech companies, I'm not sure a survey is a way to get at this, but what would make this an attractive value proposition for them to enter into this space? And provide a service that on a unit basis is not going to be very profitable, but if you did it at scale, you could make a living doing it. I think for people in rural areas, one thing that I discovered, so the second part of this tech project is doing case studies of JustFix, of statewide legal aid websites, of Citizenship Works, and of a tool called Risk Detector that helps a social worker identify whether an old person is at risk of exploitation or abuse, and then ships a score off to a lawyer. So if it's over a certain point, the lawyer will come back and investigate. One of the things that's really clear in looking at these things in rural areas is, part of it is that rural areas tend to have older people in them, and older people are not so embracing of technology necessarily. But also there are trust issues. And so people who live in small communities are not necessarily interested in the thing that comes from outside and tells them that it's helpful. So thinking about that's why it's important to know where people already go. But are there other ways you can ask them questions that would give you information about how you could get to them, or what they would trust? Like, would they care if the State Bar gave this a quality check, or something like that? I think that could be useful in designing the outreach for these services in different places, because it'll have to be different in different places.
Lori.
Did you find any data, and this is part of a survey sort of question and comment too, in your work, did you find any data, or has anyone really asked the question of how consumers want to solve their problems? Do they want tools that empower them to do things without lawyers in most cases, or with intermediaries? Because I love the question of where do they go now. I think that's really important. I would love to see us ask that, but I'm not sure I found anything in my various exploration on how people want to solve their own problems. I get a lot of choices on how to solve my medical problems, and some of those are not the best choices, but they're my choices to make. And in legal, I often feel that what we say is lawyers are your best and only option. And so I'm curious of whether you've come across any data, or if you've asked those questions. How do people want to solve these problems?
So I haven't seen a survey that asks them that directly, but I would make two observations from the way they behave. So when Tom Clark and I did our study of limited license legal technicians, people, first of all, don't understand the difference between that and a lawyer, which is totally baffling to someone who's not inside that industry. But they're very happy to have that limited service. As long as someone explains to them, I can't go to court with you, I'm going to do this part, you're going to do this part, it's going to be fine. The clients that we talked to were actually quite content with that. The thing, though, that really blew my mind when I looked at it was, so until the 2008 legal aid reforms in the United Kingdom, 60% of the population was eligible for some kind of subsidized legal service from the private bar, an adjudicare system that's just like Medicare. So you take your government money and you give it to the private bar and you get legal services for that. But then they also have these enormous advice service sector, because anybody can give legal advice. And then they have a system of ombudsmen for every regulated industry and lots of relationships with the government. And so if you have a fight with your cell phone provider here, if you're lucky, you get involved in a class action lawsuit and you get that check for 25 cents 15 years later. But there, you file a complaint with the ombudsman's office. The ombudsman investigates and then makes a binding decision. Either you have to pay or you don't have to pay, and it's done. In that context, even when law is free, people are much more likely to go to an advice service or an ombudsman. I think because they like to keep control of their problems. I don't know whether they feel empowered. I think that's a different question. But it's sort of, they feel like that's a reaction proportionate to the situation. They're getting information about what to do, and they usually can do it. So I think there's a lot of scope at least behaviorally, people would like a lot more control.
Joyce.
A lot of states are doing the whole triage sort of portal idea that is meant to address, you speak in your slides about the need to diagnose something as having a legal solution. Do you have any, it's very preliminary and I know not a lot of them, I mean there are a number that have been launched around the country, but I don't know. Well, so I guess there's two questions. One, do you have any comments on whether or not you think that's going to be a way to address some of that, how to get people to identify their problem as having a legal solution? And number two, are you planning on doing any research that those of us who are following that path could subsequently take advantage of a year or two down the road?
I mean, I think there are two key things for those things to work. And again, they're not going to work for everybody because not everybody's going to go on the internet. Like, if my employer doesn't pay me overtime, what do I think? I think my employer is a jerk. I'm not going to search my employer is a jerk on Google for how to deal with that problem, right? So that's always going to be true. This is just a slice of the pie that this would help. There are two things that are essential. So one is some kind of natural language processing frontline, like what a human would do, only done by a computer, because people don't think about these things in that way. And the other thing is those portals are only as effective as the networks of actual organizations and human beings that integrate behind them. Yeah. And going back to the autonomy point, that is really, really challenging to do just in the legal aid space. But then once you start going across lines, I mean, it's just like, there's no point in triaging you if I can't send you somewhere.
Right.
And if there isn't real-time information about whether wherever I might send you has capacity, because otherwise it's just like what we do now, only not on paper. Here's a list of 25 places, none of which will be able to serve you. Yeah. Good luck. And so I think that human coordination problem is a much bigger issue than the technical stuff, which Margaret et al. Will work out pretty quickly.
Mm-hmm. So, Donna, you did a good job of moving us toward the issue of the survey. Randy, do you want to talk about the survey?
So the survey will be conducted by NORC, who has already worked with the State Bar on a legal malpractice insurance survey and also is currently working with the State Bar on a justice gap survey. So this will be survey number 3 that we'll be working through them on. And the survey will be as many as 50 questions with a survey duration of about possibly as long as 15 minutes. There'll be either telephone interviews or through online completion. And we have this meeting, I'm afraid, as both our starting and our finishing meeting to begin collecting the categories, the topics, the questions, which do not have to be fully rendered and formed. The consultant will assist us in crafting the questions in a way that they will be effective and not biased, but we do have to come up with the categories, topics, and types of questions for the data that we would like to collect in order to inform our consideration of our proposals. And so with that, the main takeaway is think today as we go around the table and start brainstorming on the topics and questions that we would like to ask. But more importantly, after this meeting is over, between now and I hope maybe end of next week, if you could submit your questions to staff via email. And I'm going to ask if Justice Edmond would be willing to take 2 volunteers from the task force to work with leadership and staff between meetings to be able to provide the consultant with our list of categories, topics, and questions that we want to turn into a very effective survey. And the survey will be primarily adult, 18 and over Californians, as Donna was mentioning, will be the primary cohort, but that there will be oversampling for those, the poverty level, and also in the rural communities that will allow us to do some comparative analysis. And the questions will be ultimately developed by the consultant, but it's envisioned that there would be something that would include branching questions. And so there would be, say, 30 basic questions with perhaps 20 more questions that would be the result of follow-up questions if the respondent answered, for example, yes to a particular issue or no to another issue. And that type of structure will be also developed through the design process with the consultant. And so we're looking at maybe 30 questions with 20 branches. And I did provide a memo with the agenda materials that gave examples of Professor Sandiford's studies. There was a Harris poll. There was our own legal malpractice insurance survey. And so there are sort of answers to a lot of questions that are already out there. But in working with our consultant, we were informed that if you really wanted the greatest ease of data analysis and drawing reliable inferences and conclusions, that even if something was already asked, then you might be able to ask a refining or complementary question or battery of questions in your survey. Since we have 30 plus questions to play with, we ought to consider re-asking for our population that we're surveying maybe some of the same questions. Again, we think it might be the same result. It might be different because who knows? California has always been sort of marching to its own drum. We don't know. But that's really the lay of the land. When we asked for specific guidance on how to develop questions for a survey, they directed us to the Pew Research page, as they are the gurus of developing questionnaires. And they also gave us the tidbit of guidance that was in Lauren's email to you about how you should think about developing survey questions. But with that, I think we ought to really just get into the brainstorming of the topics for the questions so that we can work with hopefully 2 volunteers of the task force in leadership to give something to our consultant so that we can meet their timeline, which is based on the premise that at our August meeting, the one I mentioned earlier, August 9th, that we will have the raw data report come back from the survey at that time. The reason why we are strategizing it in that fashion is because the next meeting of our task force in October will be after the public comment period on our tentative report and recommendation. So we wanted to, as our first wave of feedback, look at the survey data in August, and then second wave, we would have the public comment and the transcript of the hearing, testimony, et cetera, come back to us in October. And that's the game plan for the follow-up on the report that we're developing, because it has to be essentially revised in response to all of that feedback before December.
Okay, the floor is open for discussion of topics, categories. Professor.
All right, I guess my first question is, who is the target audience? Is this just going to be the consumers of legal services, or is it going to also be lawyers who might be providing legal services supported by technology?
So they have a stable of professional respondents to surveys, and so they are a random sampling that is scientifically valid of adult Californians, and that will be the panel that they will seek. We can't say with any certainty that they will include lawyers, that they'll include technologists, that they'll include entrepreneurs, that they'll include consumers who are at the greatest need level, but that is why we have the oversampling for those 2 categories, 125% of poverty level and the rural. But they are a random sampling of folks. They're not targeted to entrepreneurs, lawyers, or technologists.
But we should. I just let me follow up. I think I didn't articulate my question very well, because I've heard a lot of folks saying repeatedly that lawyers, okay, we're risk adverse. I'm risk adverse. I admit it. But lawyers are afraid to do something. A lot of people are afraid because of the unauthorized practice of law. I would like to really hear from folks whether they will, lawyers, whether they would utilize these tools that we're talking about. We're trying to identify what would be good tools, and I'd like to hear from lawyers. Are they even going to use the stuff that we might recommend? And that's what I thought maybe we would have more than just a single set of questions, because I'm not sure we're going to identify or get an answer to those kinds of questions with a survey that is probably going to be just aimed at the general public and consumers of legal services.
Luckily, I would say that we have access to lawyers here at the State Bar. And so certainly, certainly there may be a benefit to doing a parallel survey, asking some of those questions to lawyers, and we can do a random selection of X number of active lawyers or active or inactive lawyers, and send the survey out to them as well, with different questions. Certainly, right? I think you're absolutely right. We want to know what are the barriers that lawyers are seeing to doing this, but we also don't want to be proposing technology that nobody is going to use. And I was especially intrigued by the Just Fix It app, because as I was looking at the list, there were a lot of things were how to find a lawyer, or things that had the word law in it, and looking at asking questions that will get sort of to the understanding of maybe what you need to do is something that really isn't posing something as a legal issue, because the people aren't recognizing as a legal issue. So I think there are sort of many pieces to this, but we definitely are in the unique position of having access to email addresses for quite a number of lawyers around the state.
So it's Daniel and Andrew and then Mark.
So as a legal tech founder, I would say one of the things that I feel is really sort of an endemic problem in legal tech is that a lot of the companies are started by lawyers, and you tend to solve your own problem. And so a lot of tools out there exist for lawyers. I think that's sort of reinforced by a lot of the UPL restrictions right now. But I think if we're really going to address access to justice, we need to encourage legal tech entrepreneurs, in the future and current ones, to pursue, a market that's a lot greater than that. So yes, I think we should definitely get opinions of lawyers that would be potential users. That's in California, like what, a couple 100,000, but the potential user base of just the general citizenry of the state is what, 40 million-ish. So I think it's sort of an education effort among legal tech entrepreneurs, but also making it known that they can work with these sorts of areas in the law that were previously not accessible to them because of UPL and those things. So I think there's sort of addressing the limitations of the current system, but also educating them on how the future system is going to work.
Andrew?
I think the issues with UPL that come up is a lot, speaking as an entrepreneur myself, and speaking with various communities of entrepreneurs, is two issues. One, it's hard for folks to find venture capital funding for their initiatives and ideas when the community is unsure if they'll be stopped in its tracks from operating depending on what they want to offer. So there's that. The second issue that continues to come up, and Dan did a great job bringing that up, is generally you see lawyers who build legal technology tools, and that's almost as a way to almost kind of protect yourself from UPL issues, or just maybe that's the only folks who are at this time continue to be interested in the legal tech space in larger numbers. But if we're going to be opening up, and when we talk about UPL, we may want to have the folks who are building these tools might not be lawyers at all. So I think that's an important consideration as well. And then just overall, what I think we all have to think about is we might be proposing, or the questions that we should be asking folks is, do they feel comfortable if a tool is built by a legally trained individual, and what the risks, and understanding from the consumer's words what they feel about that. So I think that if we're in the survey, if I can pitch for anything, it would be really asking consumers of legal services, hey, if a tool does function the way it's advertised to function, and presumably we'd be able to try to figure that out, but it was built by non-lawyers, to use that terminology, and et cetera, are you okay with that? Because I think having some strong quotes from consumers saying, I don't care if my landlord tenant issue that I solve via my smartphone is built by a lawyer or non-lawyer. That's the kind of information that I think would be really helpful, personally, I think, in terms of what we can do as a task force moving forward.
Mark, and then Joyce.
Yeah, I have a much more fundamental threshold issue that the survey would be very helpful for me anyway, and I'd like our guest speaker to comment on this, but in the readings and the dialogue that we've had so far, to me there's a fundamental distinction between the need for information and solutions to legal problems that consumers may or may not know they have versus being represented by a professional in pursuing a legal remedy or solving a legal problem as an advocate or as a lawyer or as someone who served traditionally in that role. So I would be interested in knowing from the consumer point of view whether or not what they value and what they need the most right now is understanding, having a better way of understanding whether or not they have a legal problem and whether or not they would be benefited by having resources, either real life resources or automated resources to help them solve that legal problem or understand what their remedies are, and they can then make intelligent decisions about how to proceed, versus do I want more readable access to legal services in the sense of having a true relationship with a professional, heretofore being a lawyer, to represent me, to work with me to solve my legal problem, file my claim or advocate my case or go to my employer and do something for me? Or am I satisfied by getting all the information I need so that I can go ahead and write the letter or have the letter written for me or automated out to my employer? To me, that's a very fundamental issue, because I don't think you go anywhere trying to redefine the practice of law or what's legal advice or not legal advice. I think that's a failed mission. I think the issue is how do we the law is so prevalent today that we have to get more resources to the consumer. How do we do that? That's the survey I would like to see written. And what do they really, really see as their most basic need? Because in the end, there's this huge spectrum. There's going to be people with simple legal question, and there's going to be people with a major, long-lasting, serious legal dispute that's going to take a fair amount of effort and time to resolve. What do consumers really think about that in terms of today's technology and access to justice? That's what I would start with. How you frame the question, I don't know. But I would like our speaker to comment whether or not that type of analysis makes any sense.
I think it would be wonderful information to have. I think for an ordinary person to do that with a survey would be really challenging because it would end up being so abstract. So you'd either have to ask me, what do I want when I have a legal problem? And I'd be like, well, I don't have legal problems. Yeah. Well, what if you had one? Well, I don't really know what one was. Or you can do hypothetical scenarios, but even there, it's just not the way most people think about stuff most of the time. The methods that seem to work well for what you're after, catch people when so Margaret Hagan gets people who are in court, doing something in court, and says, okay, let's have a design session where you tell us what would be useful to you. You allocate $100 to this innovation, this innovation, this innovation, and they say, we don't really care about this, but we really care about this and this. And they're experts on that because they're having that experience. Mm-hmm. So sort of finding a way, I'm not sure surveys are the best way, but I think you absolutely want that kind of information. Sort of figuring out how you would get it is a little bit trickier.
Joyce?
So Mark stole some of what I was going to say, so I don't want to repeat what he said because I think you summed it up. But I also think it would be interesting if the survey, because what Margaret Hagan does is in the moment when somebody's already at court. And I think that there is a place for, and I don't always know that technology is the solution for this, but some of the educational campaigns that you were talking about, people don't think of wage theft, they just think their boss is a jerk for not paying them for the overtime. And getting, sort of that upstream attempt to kind of capture some of what happens upstream of it being something where they're actually then end up in court, because we know so many people never actually already make it all the way. And I think that it's the, what are you trying to fix, and how do you want to fix it? I am reminded of a project that was done in Escambia County, Florida, with Margaret Hagren and the IOLTA Funder of Florida, where they went to a group of, they went into a community that had a bunch of services, and they said, how would you, and what they were hoping was that the solution would be a technical one, that they'd be able to say, well, let's put together a website, and then you can find all the information you need, and blah, 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 blah. And what the community said was, we don't want any of that. What we want is on Saturday, from 8 a.m. to noon, if all of you guys could be in one place, and then I could walk around and get all of the benefits taken care of. I could figure out my kids' school lunch, free breakfast, whatever thing, and aftercare, and some medical help for my ailing father, and do it all at the same time. So I only have to take one day off of work or half a day off. There was all of this really interesting stuff that didn't have anything to do with technology, but it was saying, what are the problems that you're trying to solve, and how do you want to solve them, and what is the best way for us to sort of meet you where you are? And I think that's, and I don't know how to do that. I don't have any expertise in creating those kinds of surveys, because I think the other thing that we sometimes miss, and lawyers in particular miss it, and I think designers of websites and designers of tools, it's something that we attempt to do, is that people don't solve their problem in one sitting. It's an iterative process. They come in and they find a little bit of information, and they go, okay. Well, now I wonder how does that affect, is that my thing? Is that the deal? And then they have to think about it we all sort of have to take in a little bit of a digestible quantity of data and think about it, and then I know the next question to ask, or I know the next thing to do. And that's sort of my hope for some of these triage systems, is that people will go through them multiple times and answer different questions different ways in order to get a sense of, what's the scale and scope of what I'm dealing with. So I think there's it's the, what do you want to solve and how do you want to solve it is really would be most helpful in the survey. I don't know how to do that, but that's.
Lori.
So I'm wondering if it wouldn't be beneficial to consider, so we know today that most people don't identify their legal problems as legal problems. And so trying to first educate them in a survey and then ask them the questions and then gather the data sounds like a survey I would never, ever respond to. And so I'm wondering if maybe we can narrow the focus of the survey to identify 3 or 4 of the top problems that are legal problems people don't know are legal, and then frame questions very specifically. So if that's landlord-tenant, when was the last time you had a problem with where you live? And how did you solve that problem? And who did you go to? If you didn't go to someone, would you have, where would you have went next if you didn't solve the problem on your own? Maybe there's a way for us to choose very specific, with no legal terms involved, if we're really trying to get the consumer focus and really narrow down those 3 or 4 types of experiences. I'm wondering how the group feels about that, because this is beginning to feel a little overwhelming. I want all the answers that everybody has asked for. How do we do that? In one survey, we probably can't, but maybe we can get a little taste of what we're looking for.
Bridget?
I think that makes sense. I would also like to know whether in that context or a different context, people's appetite for using less than a lawyer, or a different level. So, would they be comfortable? Would they trust having somebody who is not a lawyer, but maybe someone who could help them walk them through the process, just for this triple LT idea, but just getting some data to know whether consumers are comfortable with that option.
One more idea. I'd like to know, even past LLLT, like, would you go to your pastor for this kind of help? Or some of those other trusted community ideas. Maybe if we can framework some typical places we know people go when they need help. I'd love to see that. I'm with you. I think that information would be really valuable.
Great.
I have to be the lounge. Thank you for your presentation. It was very helpful for me to understand the problem that we're trying to wrestle with here. I know from the court's perspective, I mean, last year on the civil side in our court system in California, between 75 and 80% of litigants are self-represented. And so those people have identified that they have a legal problem, but they're not using lawyers. And so I'd be interested in finding out from the broader panel that we're going to, how many of them have had interactions with the court system, either federal or state court system, how they identified their problem as a legal problem, and what resources they used to do that. Even though it's a small fraction of those who really do have legal problems and may not know that they have them, at least it will give us some sense of how they were able to track it and find their way to the court system. And it might give us some perspective on what resources they do trust that brought them here. So.
Good. Mark and then Lori.
Well, Greg, I think I'd like to know statistically how many of them were dragged into court because they were going to lose their houses because the landlord, they weren't paying their rent. They're not always discovering they have a legal problem. They're being forced in there involuntarily and having to defend themselves. And the question is, how are they doing? And we all know the answer to that. So,
and to add on to that, that's a great point, Mark. And for those that are dragged into court, are they relying on any resources to help them? I mean, I would imagine the vast majority are not. But if you really broaden the choices that they can make, are they going to their ministers? Are they relying on friends who have had similar problems? That would be helpful information to have.
Well, and I love that idea. I think I'd like to know on top of that, let's ask them about their outcome. Instead of just, how did you get here and what did you do to become a part of the system? How satisfied or not satisfied are you with the actual outcome, or what outcome did you receive? I think we focus not enough sometimes on the outcome questions, and so there's data to be had in the outcome discussion that might inform us in ways the others won't.
Bridget?
I would just add, and maybe practice area too, if we could break it down by what type of problem were they in court for.
We also discussed some types of legal issues that people don't really know they have until there's a problem, like the advanced planning, like divorce is one of them. You don't know that you've gotten a bad deal until, way later, when retirement or sometimes at death, and wills are another one. So I would have no idea how to ask those types of questions, but some people may have been given bad advice that they just don't know is bad yet. And how do we ferret that out?
Yes.
Are we prepared for the conditional questions in this scenario? And by that, what I mean is, if we say we want to do a 50-question survey, the reality is, especially if we're going to do these on a conditional basis, you're going to have closer to 1,000 questions. Meaning, if you ask the simple question of, do you rent or own, the follow-up question should be based on the previous answer. So if it's rent, now you've got landlord-tenant questions that are going to follow it up. If you own, now it's going to be, say, homeowner's insurance coming up. If you ask the person a simple question like their age, they may have a thing where you've got seniors issues, or do you have any children? Now you've got daycare issues, and if you've got, they're also mutually exclusive, meaning no one person's going to answer all of those questions. They probably shouldn't even see all of those questions. Are we prepared for that conditional nature? Statistically, it's all valuable, and it's actually has to do with the way we write risk and need assessments for pre-trial. Is you apply a different weight to a different answer based on the series of things. Have they been convicted previously? Have they failed to appear for anything? If yes, when? Was it over 2 years or was it less than 2 years? How old were they when they first offended? That type of thing. Pardon me.
Leah, did you want to?
Well, I want to weigh in and say, no, I think there is a hard 50 question limit on what we're contemplating. But I want to ask a different question that I hope is not inappropriate. But I want to step back and just really make sure that we all understand why we're doing a survey in the first place, because I think this has gotten really expansive. Professor Moore, when you were talking about surveying attorneys with the particular question around would they use the technologies, I was thinking something I think different than others were. I was thinking about the Avvo, the Rocket Lawyer, the LegalZoom, where you can sell your services online. And right now, a lot of attorneys are concerned about their ability to do that because not of UPL, but as I understand it, because of fee splitting and other rules that make that sort of chill that particular modality. And I do see that as part of the access continuum, because I believe that the hourly rates for services provided through those kinds of vehicles will be less than traditional in-person models. So that made sense to me we'd survey attorneys or sort of ask specifically, would you do this if this barrier was eliminated? Surveying technologists to say, what would you do if these regulations were changed? What would you bring to the market? Sort of, it's somewhat akin to what we did at the Sandbox, where there were the folks in the room that are service providers were asked, what would you do if the state of Utah opened up the environment to allow you to be innovative? What would you do? So I could see us trying to gather that from technologists. Then when I go to the public, I think I'm struggling a little bit there about what it is we want to understand from the public. There's very rich data that's already available that documents this tremendous need, unmet need for legal services or unmet need for something that's going to address a problem that I have. We know that exists. So is it that we want to find out if they would be comfortable using technology to address their problems? Is it that we want to get at, do you care who's created the technology? Do we care not even just who's created, but who owns it, like non-lawyer ownership rules? I would venture to say that nobody in the public really cares about who owns that. So I just want to make sure I understand what we're trying to get out of these different population surveys.
I think for the consumer side, I think that we would hypothesize their answers and they wouldn't care, but I think it would be extremely powerful to have some of those quotes, because I think we're going to be up against a lot of people pushing back when we say non-lawyers should be able to create these tools and then actually benefit financially. And I think it's important for us to be able to ground everything in data and not hunches, because I think my feeling is they wouldn't care, but I do think having some folks and some kind of firsthand accounts and quotes would be powerful in us being able to kind of push things through. That was my thoughts on that.
Just coming from a product perspective, I'd be interested in learning from the consumer how they wish to receive the legal services, right? So like, how do you wish to consume this? I think in terms of whether or not the consumer is comfortable consuming services from non-lawyers, I think that questions are actually already been answered by the marketplace. You know, LegalZoom has an estimated value of $1 billion, right? Legal Shield estimated value of $1 billion, that sort of thing. So if we use revenue as a sign of demand, I would say that question's been answered. But it's, as a product person, when I build a product, I have to speak with the end user. I have to understand what's important to them, how they wish to consume that service, where they wish to consume that service, what devices do they wish to consume those services from, and really kind of get into, like, you know, what are the things that you want to do. And I think it was brought up earlier where it was a non-technical issue. It's like, hey, Saturday morning, I want to just do all of this, right? So I'd be interested in questions on the consumer side as to, like, you know, what are the delivery systems that you'd prefer, for example, or something along those lines.
Lori.
and I'm really happy, I know we have experts at crafting these questions, but I'd also want to caution us as we are building the questions and getting that information from the end users. The perfect scenario is everyone gets qualified, intelligent, rocking lawyer help, right? We know that's what a perfect world is. And I could call my doctor at home if I had a mole, and I could take a picture of it and he would tell me if it was all good. What's possible and what we want are two different things. So I think I want to caution us, because I believe that we are still functioning very highly on a one-to-one delivery service most of the time in legal, one lawyer helping one individual. And I don't think the data supports the idea that we have enough lawyers to fill that need in any circumstance. So I'd caution us as we develop consumer-facing questions to make sure we're taking a little bit of time to think through whether we're saying we want to ask them how they want those legal services, but maybe also some follow-up questions. If that's not available, what comes next? Because we certainly have developed the idea that lawyer is the only way right now. And so there's some bias there already, I think, as a consumer. And I'd love to hear your thoughts, Alan.
Well, I just wanted to clarify. For me, it was, maybe I should have said this in my comment, but I was working from the assumption that, like, whether it's a robot, an algorithm, or a human being, like, for me, it's kind of agnostic. It's more about the delivery system. Just a quick example. In China, there's an AI bot, stands about 3 feet tall. I think I can't remember, several thousand of them have been placed in courthouses. And these things are commuting sentences. They're doing doc reviews in the courthouse in China as we speak. They were, I think, released in, I want to say 2018 on a test cases. And so people there don't care, right? Like whether it's a human being or not, you know, they're happy to get any kind of help that they can. So for me, again, it's agnostic. It's just about finding how do you want to solve your problem.
Daniel, and then Joyce.
Thank you.
So I'm a big fan of what you were saying. I would also, just sort of to riff on that, I would say I would also want to know, like, what do consumers expect as far as, like, competence? You know, if the gold standard is, you know, perfect lawyer advice, not like how low will they go, but like, like we don't want that. But you know, how do we? I mean, you could do a whole 50-question survey just on this, I'm sure. But you know, I would like to see. I would like to get some information about sort of how to guide regulations around competence for algorithmic systems.
Joyce.
Yes, so I wanted to just, to rebut what you're saying, that most people really want a lawyer. I am looking at, and I can share with the task force, the evaluation that was done by Michigan on their triage system, that did ask consumers what they wanted, what they were looking for, what they wanted most. And the choices were lawyer, forms, information, or I don't know what I'm looking for. And the users were pretty evenly split. 30% wanted lawyers, 29% wanted forms, 30% wanted information, and 10% didn't know. So I think it is an important question to ask, because I don't think that most people, I think they do, there is that desire to maintain some control over the process and over what's happening and over what choices they're going to make. And the Institute for the Advancement of the American Legal System in Denver did some research where they had a alternative court-based family law resolution center, and there were lots of people who could afford lawyers who went to use that service, in part because they just wanted to maintain control over the process and be able to pick and choose and decide for themselves, you know, what was important and how it was going to play out. And so I think I just want to say that while that seems to be kind of a gut response and kind of intuitively that you know, if I could have a lawyer and I could afford a lawyer and the lawyer was going to solve it for me, that everybody would vote for that. And I'm not really sure that's true. And I think there's just value in asking the question, because I don't think we necessarily know the answer. Or we might be surprised by what people tell us.
Institute for the Advancement of Legal Studies was at the Sandbox. Yes. And one of the things they challenged us all with is this idea that the lawyer is the gold standard. So right now, our regulatory structure, we regulate attorneys. We don't regulate the services they provide. There's no quality control being done by the state bar. We don't know how good or bad anyone is unless they come to our attention, which is a very small percentage of lawyers. And so it was really interesting, this whole idea that the human lawyer makes mistakes too. And so we also have to be mindful of that when we're thinking about certifying technologies, because we don't want to create sort of this false narrative that just because a lawyer does it, it's accurate. It was interesting.
Well, that actually brings up a really interesting point. I was at a pro bono summit that our Tennessee Supreme Court put on Friday through our Access to Justice Commission. And one, I got to hear a lot of the statistics from Ms. Sanford. And I also said that wrong. I apologize. You were a genius, and your ears should have been burning Friday because you were all over our discussion. What was additionally shared that was really shocking is there was a study done of participants who did their own legal divorce forms and compared to those by lawyers. And the pro se people with no help from lawyers actually did better in terms of mistakes in the documents. And I tried very hard not to smile and act weird because I didn't want anybody to, I know why that happens, and I think there's a lot of reasons. Additionally, there was a different program where intermediators were used to help people navigate, and they were the only ones in comparison to all the other forms of legal aid that involved lawyers and lawyers who were paid that had a 100% success rate, and that was in terms of, I think, landlord-tenant. So it was two very different areas, and both times those without lawyers did better than those with lawyers, and I think that's an important, I think I want to make sure we remember that. I think that's an interesting idea to make sure as we're crafting questions, we don't assume, because I said earlier, I was asking the question, do you think people want a lawyer or want more control? And then I went and said, but we all want lawyers first. So even in our own, for those who have already believe people want more control, even I still find myself subverting back to that. And I think it'll be important as we craft these questions, we don't make that assumption. I agree 100% with what you said and realize I did the thing. I keep saying, hey, don't do this. So I think that's really interesting.
Toby.
Just in response to that, there are other studies in other areas of law other than family law or whatever else that show exactly the opposite. If you look at immigration, you look at Social Security, disability, far greater results with lawyers than without. Yeah. So you can't generalize that people are better off without a lawyer. Yeah, right. And criminal, I'm sure, would be the same.
Okay, it's about time to wrap this up. Randy, you have everything you need?
We do want to entertain some volunteers.
Yes.
Maybe two, to assist with the staff and the leadership in taking, a hard look at what was talked about around the table and turning it into categories, topics, and questions. And I also want to encourage...
I saw two hands over there. It was...
And one over
there.
Was it...
Are you volunteering? Perfect. Okay. Wonderful. I'm sorry if I cut you off.
And to the extent you can, in the subcommittee discussion, if you can reserve a bit of time after you have your main part of your agenda to also revisit the survey before you wrap up and come back, because maybe within the confines of your own discussion you come up with things like, I would imagine the Rules Ethics Opinions subcommittee might have some specific questions about relaxation of some of those standards for the consumers to react to. And so if there could be a little bit of time in your subcommittee sessions today to also talk about questions. And I don't know if Professor Sandiford could bear with us and hang around any longer, but you're welcome to join our subcommittee sessions as well if you'd like.
Alan, can we volunteer you to join the group to look at the questions? I think you bring a different perspective, perhaps. Wonderful. Terrific. Thank you very much. Professor Sandifer, you have made our morning. It really was such an interesting conversation, and I do hope you can stick around. There's lunch in the back, so we're going to take a break until about 1 o'clock when we'll break up into our 3 groups. Do we have any instruction, Mimi, on who's going where?
1 second.
So I think the group that will remain here is the Rules, Ethics, Opinion Subcommittee. And so that group will reconvene at 1 o'clock here, and you'll be live streamed. So you'll be the one accessible to the public through our facility. The
ABS MDP will be in 8B upstairs on the 8th floor. You're going to need a staff person to scan you to go upstairs. And then the other committee, the UPL-AI, will be in 8A right next door.
Yeah, so we'll when you're ready to segue to the subcommittee event.
And I think, is it the case that UPL-AI does not have a quorum and so can't take any action today? You can obviously sit and talk about whatever you want to talk about, but in terms of taking action, you don't have a quorum. Okay, let's break for lunch. Thank you so much.
Like that, now they're protected down south, but yeah. Can't turn it off.
Whenever you're ready. Okay. All right, I think we're going to get started. So let's start with a roll call.
Laura?
Here?
Evan?
Here.
Johan?
Present.
Lori? Here. Andrew?
Present.
Daniel?
Present.
Alan? Here.
Is that everyone? Okay. And then can we have someone take notes for... Great, thank you, Lori. And do we need to approve the action summary?
From the last meeting.
Has everyone read the action summary from the last meeting?
Yes.
I'll make a motion to approve the action summary.
Second.
Anybody, any comment? Anybody against it? All in favor?
Aye.
Who seconded it? I'm sorry.
And so I think it passes?
Yeah.
Okay. So just, I guess, a few housekeeping things. Lori, we got your letter, your memo, in response, and I think we're gonna leave the decision as it is, as it stands. But just so that you know that there's going to be plenty of opportunity to share your dissenting opinion, and no one takes it personally. You're welcome to do that. And even the decision that we came to is not without. I mean, there's people on very opposing sides, and that was just sort of the middle ground that we all said yes. We all think that this middle ground is kind of the minimum that we need to do on this issue, with some people thinking it should be black letter and other people, sort of disagreeing on some of the specific language. So none of that is anywhere near stone, and there's going to be lots of opportunity to share other opinions, but we, follow the procedure to reach an agreement, and so we're going to keep that.
So I think that's part of the issue is I'm feeling very lost in what that procedure is and how we're coming to those decisions. And so it wasn't so much that I felt like I had a dissenting opinion. It was that I thought we were talking about hypotheticals, and then it went from that to we're drafting a motion to make a change to a rule. And it felt like we went from hypothetical discussions to a motion. So I want to be clear that I don't expect us all to agree. I think I think I even have some confusion on, does it take a unanimous versus a consensus? Like, I feel like the process isn't well established in my mind. And so maybe that's where, that was really the crux of my statements, is it feels like I'm often feeling very confused and confounded by what's coming out afterwards, and that may just be me, but there is it feels like a lack of understanding, at least on my part. So I didn't realize we were making a motion to change the rule to add a comment. I thought we were deciding if we did decide to do that, this is the hypothetical language we could all agree on.
So it's somewhere in the middle. I'm going to try and clarify, but please, anybody else, feel free to explain this better. So all we did was basically make a motion for our subcommittee to bring it to the whole group and to share. We've had this discussion. It's a very limited issue. Everything else we've been way out here. And so this was something where we were actually, way more central in far as our opinion, and because no one else has done any action items yet, it was kind of new for all of us, so it was a good way for us to start figuring out how this process works. And so what was shared with us was that we would then put that in writing, which we did. That was part of the homework. Kevin and I worked to put that in writing, and that was disseminated to the rest of the group. And then I don't know at what point the whole group will talk about that, but maybe someone else wants to chime in about what the next step looks like when we have an action item like that?
Sure. This is Andrew. I can speak to that. So to answer Lori's previous question, we follow the general direction of Robert's rules. Unanimous decision-making is not necessary. It's just the majority vote on most items. But going to Tara's point, the subcommittee can make recommendations, but the full task force does not make a recommendation until we're back in what we've been referring to as the plenary session. How we get back to the plenary session with this item is less clear, but let's say we make a formal motion and recommendation regarding the language as presented in Kevin's memo, then staff would notice that on the next task force agenda, if it's not noticed on today's agenda, I'm not sure that it is, and then they would consider it at the May meeting, and there would be a full discussion amongst the full group, and then there would be a motion and a second, and then a majority vote of that group would either vote it up or down.
And I think I'm clear with that part, and I'm not sure if I'm explaining myself well. I think, again, my concern was I was very confused by what we were actually voting on at the last meeting, and maybe some of that was because I wasn't in attendance. But we were discussing hypotheticals. If we decide this versus this, then this is the language we would use, was my recollection. And so we all voted on that language hypothetically, and then I saw we were drafting a motion. So I think I'm not sure that changes anything in how I would have voted anyway. So I don't want to spend a bunch of time on something that might not matter. But I felt like we were pushing a vote on something we all agreed on that maybe isn't advancing the ultimate goal of our subcommittee, which is dealing with all of the rules and how we're going to change them. Instead of, we talked a lot of hypotheticals. So I just got very confused. I just am throwing that out there in case anyone else felt that way. At one point I wasn't sure which rule we were talking about, and so maybe just a little clarity as we go through how we're talking about the rules and making sure we're making decisions as a subcommittee and maybe not talk about hypotheticals, because I think there's a lot of room for confusion if we go from hypotheticals to motions. If the rest of the group finds value in that same process.
Okay. And I just wanted to clarify that it wasn't my motion, it was Tara and my motion. So it was a joint motion rather than just me. I'm not sure how my name ended up on the memo, but it was both of us had input.
I did that on purpose.
Okay. It's him.
Yeah, and as we go through it, we'll be sure to just pay closer attention to that in general. And so one of the questions we had was for Joyce, and so we'd like to hear from you. And I forgot what rule it was actually.
5.7.
5.7, and you spoke with a few other states, so if you could just let us know what information you got, that'd be great.
So my understanding was, and let me read because I did come back and ask for some clarification. I sort of walked out of the meeting like, I know what I'm doing. And then I got home and I was like, no, maybe I really don't know. I have any idea what I'm doing. So before I started asking, there were two states first off, there were two states in particular that have created task forces similar to California. One is Arizona and one is Utah. And the Utah one, I've had a much harder time connecting with. I know some people in the legal aid community there, and I know some folks at the bar, and so I just started asking around to try to find a connect. Do you want to go ahead? I'm sorry.
Yeah, so the representatives of the Utah Supreme Court were at last Friday's workshop at Stanford, and I was able to get one of the justices sidebar, and because I promised I'd try to track down some information, so I expressed our inquiry in terms of California not having any version of ABA Model Rule 5.7, non-legal or ancillary business services, and the fact that they've had it for a while, pretty much spot on with the Model Rule version, and wanting to know if they felt, since they're taking a hard look at this topic of access right now, if Model Rule 5.7 had any impact on the development of delivery models or greater access because law firms or lawyers were actually availing themselves of the option of rendering non-legal services pursuant to that rule. And they didn't have any specific data that they could refer to, but they did say anecdotally they really did not see that rule having too much or any impact whatsoever on law firm delivery models in terms of legal services. So short of them going back and doing some closer looks or checking in with their staff, being that they're in a place where they're looking at access, I would imagine that if that had been something, that they might have been briefed on it in their ramp up towards all of this. But it doesn't seem to be the case, at least anecdotally from the justices who are directly involved in the study of access improvement. 5.7 was not on their radar at all.
Was it valuable as a safe harbor? Did they perceive value of it as a safe harbor?
I didn't pose it in those terms.
Yeah, and the person that I talked to in Utah, and I will pull it up here, was from the Utah State Bar. Let's see if I can. Nicholas Stiles, and he definitely came back and just said he didn't think that there had been any impact. You know, he just didn't have a sense that anything had happened and anything had changed in any way with the implementation of Model Rule 5.7. And I did want to say, just because I'm not a part of my confusion when I was asking about this, was and I think it was Kevin who framed the question more clearly for me. The purpose of me asking was that the subcommittee thought that perhaps we could inquire of other jurisdictions that have empaneled committees and task forces to explore how to improve access to justice, including Arizona and Utah. I think our interest would lie in whether a law firm had, for example, established an ancillary business that facilitated their delivery of legal services and permitted them to offer legal services at below market cost. And so that was the way it got phrased, and that's the way I talked about it when I connected with Nicholas Stiles at the Utah State Bar, who came back and said he didn't think any of that had happened, but again pointed to the fact that they have not done a study specific to that question, and he didn't have any data to support it. It was just kind of his anecdotal experience, and that was one of the two states that I knew that had task forces similar to this one established. And the other one was Arizona, and I had connected with, I know out there a couple of people who through the University of Arizona School of Law do some work, and connected me with someone named Billy Tarascio. I'm really horrible at names, so I'm just going to leave it at that. Tarascio? Huh? Billy Tarascio. Tarascio, thank you very much. That was quite lovely. So I actually interviewed her. She is a lawyer. She is on the Arizona task force. We didn't speak specifically about the work that the task force was doing, but she has created a low-cost A2J arm of her law firm. Her law firm is Modern Law, And you can find it online, and I have the links. But their A to J arm is called Access Legal. Arizona has a program of licensed legal document preparers. Now, this is this is not at all like the Washington State Limited License Technicians, who are licensed to practice within specific practice areas law. So they are licensed practitioners of law. It's just a subset of what a lawyer can do. And these licensed legal document preparers are able to prepare documents, but they do not practice law. They are not licensed as lawyers, and the barrier to becoming and securing this licensure is much lower than the Washington State. And I don't know, and I've heard from a couple of different sources, again, anecdotally, that the Washington State program has a small number of licensed LLTs, in part because it took them so long to come up with the guidance and the rules for how these guys were going to be licensed and what they could do and what they couldn't do. And they are regulated by the Washington State Bar as this subset of lawyers because they are actually licensed to practice law. The Arizona model is that it's a document preparer. And Billy, say it again. See, and I'm gonna point to you, Alan, every single time I have to say her last name, Tarasio. And she had to secure an ethics opinion from her bar to tell her how to structure this business so it would comply with Model Rule 5.7 and any other ethics rules of the Utah Bar. This has turned out to be a very lucrative business for her. The LLDP, so licensed legal document preparers, are not lawyers, do not practice law, and they blah blah blah. She owns Access Legal, but she does not supervise the document preparers because they're not lawyers, and they're not paralegals, and they're not LLTs. They're this completely different animal. They provide a free consultation by phone with information on which forms to select and use. And I did actually go into the system and entered the information, and I did it over the weekend, and I've subsequently gotten a phone call and a text message and an email. So they're definitely right on it in terms of following up to see, because they're viewing me as somebody who wants to, I went through some of the divorce stuff just to kind of see what I could see, what I could do, get a sense of. But I think there's some value in that, exploring that model. I don't know how it impacts the model rules because I'm a technologist, and I'm going to just, I'm going to wave that white flag and say, I don't know what that means. But I think it's an interesting way to do it. She also suggested, she kind of chewed my ear a little bit about doing away with the fee sharing rule, which I believe is Model Rule 5.4, the fee sharing, as it doesn't, say it again? With non-lawyers. So she said it doesn't prevent fee splitting in actual practice. And she says in the entire history of the rule since adoption in Arizona, there's been maybe 10 complaints about fee sharing that have been filed with the Arizona Bar. So that's all entirely anecdotal. There's no data to support that. But she was just like, well, if you're thinking about this, you ought to be thinking about, Model Rule 5.7, you ought to be thinking about Model Rule 5.4 as well. They don't, but she just thinks they ought to do away with it. And she said, if you're in it, that's, I think, part of what she is recommending in her capacity on the task force for Arizona. And she was just giving me the what for about what I should be telling y'all to do here in California. And I was like, well, thanks for the heads up because, so, everybody's input is welcome. So that was kind of I think that is everything. Let me check to see my notes for Utah just to make sure I didn't miss anything. Nicholas did say in his email that he would, after all the stuff about he doesn't know, said he would ask around and get back to me, but that was 9 days ago, so I don't think we're going to hear anything. But that's the summary of what I think I was supposed to do. Yeah?
The question I have is going back to Billy Tarasio's sub-entity.
Mm-hmm.
She owns that entity.
Yes, she does.
But when it's advertised, is it advertised as being associated with her law firm? Or is it just a completely separate entity that she happens to have an interest in?
It's a completely separate entity, but you can, through that process of going through and saying, I want to do my own divorce, or I want to do my own thing, or fill out forms. There were lots of opportunities, but if you want a lawyer, then they do a lawyer referral to modern law. So I do think there is a pathway to get to her, but it's not presented on the website in any of the stuff that I saw that said this is a subsidiary of modernlaw.com. It was a completely standalone entity. Does that make sense?
Yeah, let me explain the reason I asked that question, because when I was going through Tara's memo again and looking at it, the idea of we pretty much before just discounted that the advertising rules wouldn't apply. But I think the advertising rules might apply in a situation where a lawyer owns a sub-entity. The sub-entity is marketed as being owned by a lawyer, yet no lawyer ever supervises any of the services that are being provided. That could be potentially misleading to the consumers. This is not an opinion, I'm just saying these are the possibilities that we
Yeah, it happens all the time.
Well, I think it's also interesting that this sort of neutral platform, I mean, it's not a neutral platform, right? Because it's developed by her and only feeds her firm. I don't know off the top of my head whether that would violate any rules, or maybe it's not a problem. But I do think that's also interesting.
And it's accesslegaldocs.com. It's easy enough to pull up and take a look at. It does not appear to at any point on here do they say anything about modern law. They're, but I do think that if they have an opportunity of hiring somebody from her firm, from the modern law firm, but it just does not appear at all to be, referral network of professionals. Well, let's go see what that. Process servers, investigators, support groups, business valuations, attorneys. So that's kind of ancillary or what we think of as affiliated professions, not lawyer referral
There are a
service.
few attorneys. Hers is number one, and then Michelle Ogborn. So there's 3 attorneys, of which hers is the first listed.
Well, and her law firm, Modern Law, I bet they're all attorneys for her Modern Law because she has more than one in her firm. Bet you $1.
Now I want $1. Let's see, yeah.
While you're pulling that up, can I just make a comment about this? So, like LegalZoom, owned by lawyers, right? So there's 3 lawyer co-founders. I think that's been their advertising since the late 2000s. Use your microphone. Oh, please.
Thank you. So like LegalZoom advertises, founded by lawyers, Bob Shapiro, Brian Lee, Brian Liu, all 3 are lawyers. They don't work in capacity as lawyers, right? Like they're not checking documents as document automation or document assembly software that puts it all together. But it's just a comment, like I think Johan just said it happens all the time, and I'd agree, it happens all the time. So, founded by lawyers for consumers, that sort of thing.
As long as they have an express disclaimer that says we're not going to review the documents. But if
I've never read through the terms of service, and maybe they express that.
I thought LegalZoom had a secondary review process.
They do now. I mean, that's when I worked there, that was my job to create that, right? So there's a legal plan or a subscription plan that a consumer can take advantage of, like document review or legal advice, that sort of thing. But I worked on that in 2010, and LegalZoom had been around since 2002. But again, just making a general comment, like this happens in the marketplace now all the time without, to my knowledge, prosecution by State Bar or anything, right? So.
Also, I think Joyce owes me $1. At least the attorneys listed, they seem to have their own independent firms, and they are not listed on her website. So.
Well, fair enough, then I will pay the $1. For one place, I should not, well to a bet, right?
Well, thank you for that information. I mean, that's definitely what we were looking for, right? We just wanted to know if anyone else had answers, and I think those are two good answers. Alan? Oh, Andrew.
It's me, and maybe this question is best for Randy or Andrew, and that is, what would be most problematic in California about Billy Trasio's business?
Well, the lawyer response is, I don't know if we have solid facts on which to base an absolute opinion, but just some observations in general. One of the things behind the curve then on Model Rule 5.7 is that it does say that if a lawyer owns or operates a non-legal service and it's sufficiently distinguished from the practice of law and they make it clear to the consumer that I'm not being your lawyer in this non-legal service activity, that in the delivery of that non-legal service activity, you're not bound by all of the normal rules of professional conduct and attorney-client relationship duties that would normally attend to that service. But it doesn't mean that if a lawyer, for example, took in a client in the first instance and said, well, you could hire me and we could do it this way, or you can use my other service, that transaction with the lawyer wouldn't be immune from scrutiny. And so you might still be bound by certain conflicts, obligations, and other things when that happens. And I think that can be an issue. In California, you're also prohibited from compensation for referrals unless it's like a gratuity or a referral from a certified lawyer referral service. And you are prohibited from directly or indirectly engaging in in-person or telephone solicitation. And so if the intake was through the non-legal service, the document provider, and they said, well, you're beyond what you can do through document preparation, you need someone to represent you in court, you need to hire X, then that might be viewed as a direct solicitation through the owned entity. But those are just, again, not knowing enough about how the actual operation practice occurs, what is feeding what, and what the relationships are. There's always something. Mia's right there. One of our prosecutors can tell you, you look hard enough, there's almost always something you can find that might be somewhat questionable. Andrew, did you want to add something?
I would agree. Randy posed the question well. If it was the non-legal business that created the relationship, the lawyer might face an improper in-person solicitation issue. And then conversely, if you were the lawyer and you consulted this person in a legal capacity and you referred them to a non-legal business, then the lawyer may want to consult in California with Rule 1.8.1, which is a business transaction with a client.
Tries to avoid the self-dealing aspect of it.
Exactly. So
is it clear that this is actually a non-legal service, though? We keep referring to the document preparers as a non-legal service. Are they actually a non-legal service, or do they have the authority to perform some form of legal services as document preparers?
They're only allowed to prepare documents, was my understanding from, and we could look at the site itself, and it is the name is Access Legal Docs.
Right.
So, I think, it's one of those lawyer definitions of that term that, your average person probably would not make the distinction between a legal, if I was in Arizona and I went to this service and I purchased that, I would say that I had purchased a legal service, even though I think the lawyers in this room would say that is not actually what I purchased. What I purchased was document preparation. But I think the distinction, it's a vocabulary, right? It's like saying, I don't have a good example. You guys know what I mean, right?
Could that happen in California?
Thank you, Kevin.
I think that's the question is, in California, could that same model be created here? That would be, I have a question for that.
Professor, I want to, well, I don't know if I'm actually clarifying your question, but you'd mentioned under 5.7, which we don't have, that she would be exempt. They do have it. We don't have it. And so I also want to know, could that exact model be implemented in California?
Okay, I'd want to see the language that they use, because most jurisdictions use the ABA language. They don't refer to it as non-legal services, but law-related services.
Mm-hmm.
That's when the rule kicks in. Whereas there are maybe a handful of maybe 2 or 3 jurisdictions that have used the term non-legal services. And I'm trying to remember what
I can read it to you now. So under the rules of professional, I'm on the State Bar of Arizona's website, under the Oh, no, this is ER 5.7 now. Is that something different than MR?
That means ethics rule.
I'm sorry, same thing?
It just means ethics rule.
Okay. A lawyer may provide to clients or to others law-related services as defined in paragraph B, either one, by a lawyer in circumstances that are not distinct from the lawyer's provision of legal services to clients, or by a separate entity which is controlled by the lawyer individually or with others. So I think in Arizona she controls it, but she specifically said she did not supervise the work of those legal document preparers, which it's my understanding are licensed by the state to do that work without the supervision of a lawyer. So she owns the entity, but she does not supervise the entity. So I don't know.
Does California have a similar licensing program for document preparers?
That is,
Yes.
I don't, yes, they do? Okay.
Yeah.
Okay.
Wait, I don't think we have an answer to the question. Would she have attorney liability for that entity in California?
It's going to be under the case law, and it just would determine, under all the facts and circumstances, could the consumers have been confused, or could she have been held? I mean, I'm not sure that this is a situation where she, with the services that are being provided, that she could be held to be in a fiduciary relationship with the customer. That's where the California case law draws a big distinction, is where the lawyers are providing services, say some sort of trust work that isn't specifically legal services, but they're doing stuff off to the side that might be viewed as confusing, and they're acting in a fiduciary capacity with the customers of the ancillary business in California, then you would be subject to the rules of professional conduct.
And I think I want to be clear, my question was not about attorney liability. I think that anytime we get into these discussions, it feels like sometimes I'm always approaching this from the consumer-driven standpoint. So my question was, in California, could a group like Access Legal be opened up where people are preparing documents that are not supervised by a lawyer, but have to be, I think under our current rules, have to be owned by a lawyer. So I'm always less concerned about attorney liability. I think we spend a lot of time in this subcommittee from the attorney standpoint. I'm really asking, could that same model work here?
So I can't speak to the legal specifics, but that was LegalZoom's model.
Okay.
Period, right, so they're certified document preparers. They've been operating in California initially since 2001 or something like that.
And there is a certification process in California?
Yeah.
We do have certified document preparers.
Okay, that was my question.
And
It's rather minimal. You
in that scenario, she'd
basically
have to
post bond and you get certified. You have a business card that says, I am not a lawyer. You have to post a sign that says, I am not a lawyer. You're not allowed to give advice. It is the glorified codification of a Scrivener service.
So fill in the blank only. Do we think My Modern Law's Access Legal does more than that?
It sounded like...
Well, I can call and follow up because they're calling wanting to know if I want my divorce or not. So, I mean, I think I'm sure, I don't know. I mean, I think we'd have to go through the whole process to find out, and I'm sure that the answer, varies.
Can bring up one point? So again, this all ties back to that UPL thing. So I'll use LegalZoom as an example. Actually, the State Bar is a good example. State Bar has a will form available on their website. And LegalZoom offers a simple will on their website. And if you're filling out LegalZoom's simple will, for example, say, I don't know that this is an actual question, but say it says your total gross assets. If you were to put in, say, $1 million, the software should say, whoa, hold on. Like, if you're worth $1 million, you need to consider other legal instruments to help you with maybe estate planning. Please review this living trust or speak with an attorney. But if the software did that, at least when I was there working with James Peters, we felt that would be UPL. Mm-hmm. And so the software just allows you to go screw it up, right? Like by putting in that $1 million. And so, but on the State Bar website, there's an actual form. It's a simple will form. You just do a search on the State Bar website. And in the instructions there, it specifically says, if your assets are over $600,000, then you shouldn't use this form. You should consider something else, right? So, I guess getting back to the thing, yeah, you can start that business here and all that, but it's got its limitations. I mean, those businesses operate now, it's this UPL question that needs to be addressed, right?
I agree with Alan, and I think that's maybe why I was asking the question, because I feel like our committee has spent a ton of time talking about how we increase attorney-driven innovation, and I'm approaching this from I think we came up very quickly with the idea that the rules don't prohibit attorney-driven innovation. And so the rule changes aren't necessary to allow attorneys to increase innovation. There are other factors that stop them from innovating. So I think I'm very familiar with my modern law. I'm betting Alan is, and there's probably a couple more of us. She's in the same legal tech circles. It's a really tiny circle, and that's a great way for an attorney to provide additional services. I'm wanting us to kind of think through how we change rules that increase innovation that isn't possible right now. And maybe I'm jumping ahead of the game, but I think, Alan, I was just trying to find out, isn't that already possible here? And if it is, are there lessons we need to take from that?
Well, I mean, my question was not about, to Professor Moore, was not about liability. It was generally, can it be done? And yeah, it can be done, but there are going to be limits on it because of the unauthorized practice of law. Right. So that's very clear. That's one problem. Just like you said, it is just about filling out documents. And doing estate litigation, I see this all the time because document preparers, that's something that they do, is they do wills and trusts. That's a really common area of practice. And they get it wrong, but so do attorneys. But it would be nice if they could offer a little more guidance such that they could help people. But I do think it's important to keep in mind that the State Bar regulates attorneys. So
bingo.
That is, that's the situation we're working with.
But we're not only tasked with changing the rules as it relates to innovation for lawyers, right? I think that's maybe the one thing I'm struggling with right now with what we've done so far.
Yeah, the last two words of your statement, for lawyers. You're exactly right.
I feel we're coming up on a place where we have to provide some real recommendations very quickly, and I feel like we've spent almost all of our discussions have been attorney-driven. The public policy concerns as they're drafted in the memo you did are all from an attorney perspective. They are not from a consumer perspective. And I think that I'm really struggling with, can we make recommendations on rule changes, like specifically fee sharing, UPL, that do away with that completely? Are we tasked with waiting for what the other subcommittees are coming up with before we make recommendations? Or can we have real recommendations, conversations, and votes on changing those rules now?
You move it, I'll second it.
Well, a few comments. First is that everybody, including you, has the opportunity to put in your own comments on the memo, just like Andrew did. And so it does not have to be one-sided. You've had 2 months that you can contribute your opposing opinion for each
Sarah, I need to be
rule.
really clear about how I feel about that statement, because that's like the third time that's been said since the last meeting. The reality is we're on a very short time frame, and I don't want to waste time quibbling over the wording in a memo. The point that I was making is we've put out a memo already that supposedly has the compilation of this subcommittee. And I think the public policy concerns that are in that memo were not addressed in our last meeting, even though they were first on the agenda. They're not going to be addressed here unless we force the issue. It appears we were going to gloss over and just say, provide in writing your comments. I don't want to quibble over things that don't matter, but what I am saying is it feels like we're spending a lot of time talking about things when I really thought our mission was to make recommendations about rule changes. And that's what I'm asking for, is can we get to work on making recommendations about rule changes that aren't just adding comments to existing rules that increase attorney innovation?
So I think I do need to clarify something. You could just add a new paragraph here. It's not something that we need to agree on. You could just say under 7.2, under policy issues, you could say alternative issue, or alternative perspective, and just write in a completely opposing thing. We don't have to I mean, it doesn't have to be
I
something
did
that the
that.
rest
I
of
mean,
us
my
agree
paragraph was
on.
the same, that it is a one-sided, limited view of the public policy concerns, and I don't think it represents a protectionism for consumers. So I think I did that, and I don't want to get bogged down by a memo or a document. I am concerned that every time we put something out, we are essentially saying this is what this subcommittee agrees is important.
So I think that's not accurate, because this is just a working draft. So, and this is what we're building on to make the overall recommendations, which I do think are somewhat, waiting on these other types of issues, which could make sweeping changes to all of these things. So it's.
Do you believe we need to wait for the other subcommittees? That's what I want to make sure I understand. Because you think we need to wait for the other subcommittees before we make recommendations on rule changes?
I think it depends on the rule, but I think it's also entirely appropriate to take one of these rules. So, for example, to go through it and say, okay, Rule 1.1, public policy concerns, that you could write right under that rule, this public policy concern is attorney focus, and it does not actually have to, this is the other perspective to that. I think Rule 0.1, the idea that's written down here, I think that's wrong, and there's another perspective. And then you go to Rule 1.2 and say, actually, I do think that scope of representation is important. I agree with that, and maybe there's no comment to that. And then go through the next rule, because not every single rule, I would think, I don't know that you agree with that position for every single rule. So I do think it's important to put those ideas directly into this format. So as we go rule by rule, we can see, okay, here's one side of it, and here's the other side of it, and then we can have that.
How much time do we have to make the recommendations on changes? When are they actually due to the larger
Oh, we're way
task
behind the
force?
power curve. If I may,
And
because I
I'm sorry,
think we
one
can do
second,
both.
Joe,
Go
if
ahead.
you don't mind.
Yeah,
I'm actually asking for when are they, or maybe Terry, you know that, when are they actually due to the larger task force?
I don't.
Well, we do have to begin elevating things that have a substantial consensus here to the full task force starting this meeting and the next meeting, because these two meetings are leading up to the refinement of what would be the actual report text that we would do in June. And so it looks like the memo is really just a representation of an organizational structure or how to move through this charter. And so I really think it might just be helpful if you just started at the top and just moved right on through each rule and just dispatch it with the information that you have now. And to the extent you can be conditional, I think we are getting signals from some of the other subcommittees and from the full plenary sessions that there might be an entity regulation model that is under consideration. So if your first pass at a rule is, well, right now we can't see any change to this rule that would help access either through technology or any other means, but if there is a proposal for entity regulation, since this rule says that lawyers cannot engage in in-person or telephone solicitation, we might recommend the concept of an exception for a certified legal tech entity to actually be allowed to engage in those types of activities, as we think that kind of direct outreach is necessary to make that access, system available. And so if you just go rule by rule, starting with...
I'm all down for that.
I think that's what we were doing last time we met, and we started with Rule 1.1, and we came up with a comment.
A comment based on a hypothetical, and we've got two meetings left to get through the rest.
I just want to clarify one other thing, is that the public protectionist issues here, or public policy issues, that's not something I necessarily agree with or disagree with. That's just why I think the rule is the way it currently is. That's not to say that it has to stay that way as well. That's just part of our task, is to, that's just part of it, is that's why that rule was there, I think. But again, I do think we need to build on it, and with that, I would like to move forward, but.
I just want to say the one last thing, which is, Lori, and I agree with your statement, is we can determine whether or not we even want to address this rule based on whether or not it turns the dial. So if 1.1 is not going to significantly affect access to justice or, improve protection for the citizen, we can just say, next, move on. 5.7, it's not been adopted. We don't find any value in any other jurisdictions, and the safe harbor is not of value. Next. We can get through these rules like that. We can even cut these rules out or recommend the removal of the rules or opening of the rules.
Yeah, and I don't think we can do, I understand we're just making recommendations. I guess I'm feeling like, and I may be the problem, but I feel like I am waiting in a mess of words and things that don't represent anything that I think I bring to the table. And at the end of that, we haven't made any recommendations but one, and even that I'm confused about. And so I guess I'm just feeling the burn of the time frame, and I'm just wanting a little more structure and seeing if we can actually make some. And I think the public policy concerns in your memo represent a valid point, a valid representation. But they are written from a very particular perspective. And so I agree with, we just go through the memo and have those conversations. I don't want to do a point for point perspective. I really just want to talk about, do we change the rules, and if so, how? And it feels like we've been kind of on hold with the exception of 1.5 of the rules so far. And I'm just looking at the very long list of rules we have that we need to make recommendations on. And I have feelings about all of them. So I'd like us to have time to discuss them and make those recommendations.
So, unfortunately, we're limited in time, and so that's why it's helpful for you to put your thoughts in writing between meetings so that the rest of us can receive those and read them before we come together and to help facilitate the thinking. So I know it's time consuming, having done the first round here, and I'm sure Andrew spent quite a bit of time as he went through and made comments, but that is really helpful. And then we would have your perspective in writing, and then we could process it, at a faster rate. So.
I'm happy to do that if that makes sense, but I think we have 2 meetings left. So is that going to get to you guys and that's really my point is, it's not for lack of effort. We put a lot of work into the first memo. We understand how much work that takes. I'm just really wanting to focus on the rules because I thought that was our task.
That's what we've been doing. That's exactly what we did the last meeting. We just only get through a rule or in half or so per meeting.
Can I just give the perspective from the court, which approved all the rules based on public policy considerations? A lot of them are long-standing. Some we've made changes to in our last revision effort. From our perspective, what we're looking for from this group, we're hearing the drumbeat. The rules are a huge impediment to developing technologies that will help bridge the gap, the justice gap, and provide access to justice to people who cannot access legal advice. What I'm sitting here waiting for is specific examples of why the rules create that impediment. Is it that there needs to be more clarity around how these rules apply? Your example from LegalZoom, I was sitting here thinking personally, I'm not speaking on behalf of the court, just personally, that does not sound like UPL to me. What you're asking somebody is, how much money, what is your net worth? Oh, wait a minute, you should go talk to a lawyer about this? That doesn't sound to me like you're getting legal advice. And you wouldn't be running afoul of UPL laws.
I agree. I think the comment was recommending, say, that they explore a living trust specifically, because that's recommending a specific instrument. Yeah.
I'm just telling you that my job is to be skeptical about changes to the rules.
Yep.
And so what I'm looking for are specific use cases where, if but for this rule, we would be doing great things in providing sound legal advice to consumers. Because the UPL, and the other thing I want to emphasize is the UPL rules are there for 2 reasons. One is consumer protection. The other is to protect the administration of justice. And as Professor Sandifer said, although there are all these people out there with problems that they haven't identified as legal problems, we still don't want all those people rushing to court once they realize it's a legal problem. We want them, because there are a lot of legal problems that can be solved without intervention by a court or even intervention by a lawyer. They just need the information. So I guess what I'm sitting here thinking is, and it may be in terms of the lack of time that you have, rather than going through the entire 69 rules that we have and saying, is this an impediment? No. I think we kind of know the subset of rules that appear
We've already
to be
broken it down.
an impediment. But the problem that I have with Professor Henderson's report, with the presentation today, is that we are really good at defining the access to justice problem, and the fact that there are all sorts of people out there that have legal problems that don't know they're legal problems. But at the end of each of these presentations, there's always a final bullet point that says, oh, and by the way, if we were only to tackle Rule 5.4, all of this would go away. That doesn't convince me at all.
Well, and
I still don't know why 5.4 is impeding a lot of the services that would otherwise be provided to these people.
And I appreciate that idea, but I think so if I'm looking at it from a public protectionism standpoint, starting there, first of all, if what you've built keeps 80% out of the system, then that to me is all the evidence you need that your protectionism is broken. If 80% and if there are all these unmet legal needs, you're asking for, it feels like we're saying, hey, show me something that works or some data that shows this will be fixed.
But 80%
and that doesn't
may not need a lawyer. I mean, 80% of the people coming in the civil side of our system right now are not represented by lawyers. That doesn't mean 80% need lawyers. And as somebody just pointed out earlier, we don't have enough lawyers to deal with all the people that are coming.
I pointed that out. And what I'm saying is, but the rules, the real threat of UPL is one that keeps entrepreneurs and tech companies from building other types of legal services.
So that's the discussion that needs to happen, I think.
Yes.
Because, okay, Texas has a definition for what the practice of law is. We don't. Have you guys discussed that?
We have not.
Well, we've argued it.
Well, there's
I argued it last time.
There's also another group that's focused on specifically the UPL.
Well, there's definitely overlap between the groups. I mean, it's hard to discern where one group begins and one group ends.
I think that's been my confusion all
I think
along.
they already concluded that they didn't want to define the practice of law, that would not be a productive pursuit. The ABA tried it, the ABA gave up. Most jurisdictions that have tried it have given up in trying to define, finding a bright line rule as to what is the practice of law.
Which begs the question, if you're not a lawyer, how the heck can you figure out if you are getting into UPL if no one can give you a clear definition? And so what I'm saying is you lock out people who are not lawyers from the space because of fear of UPL. Because I, as an entrepreneur, could not go and say, where's the definition of UPL so that I don't commit UPL? Instead of everything is potentially practicing law if a lawyer does it, that makes investment harder. And I think we've had a lot of conversations here in this group about how that locks out legal tech and investment.
Well, the other way to approach it is not to define what practice of law is, but to define what it's not. And that's another way of doing it. Like certified document preparation or other examples. Because it is going to be difficult to come up with a definition that's going to apply in all cases. And I think even Texas's definition is open to interpretation. So it's not always clear.
If I can add, maybe it's not just defining also what it's not, but like eliminating the rule altogether, but with the addition of, if you're not a trained attorney, disclosing that, right? Like full disclosure, I have not gone to law school, but maybe I'm a certified document prep person in a particular form. I'm certified in a particular form. I could be very transparent, and we can have a rule that requires that level of transparency that says, use at your own risk, right? I'm not a lawyer. I'm certified in this sort of thing, right? So, I mean, can we make recommendations to eliminate rules?
Yeah.
Eliminate or adjust, absolutely.
Yeah.
And you can always just ignore it and steamroll right through like I do.
Well,
So I think what Greg is saying, that we need some evidence-based reason for recommending to get rid of a rule.
Exactly.
And
I don't think the argument can be to get rid of this rule and make our business a lot easier.
But I think that's unfair, because I think what you're saying is we're talking about doing something that's never been done in the United States and has just recently been done in the UK. There is no evidence yet that that's going to fix it. what there is evidence is that what we're doing now doesn't work. And you're hearing from entrepreneurs who create innovation in lots of spaces who are saying if you want to increase innovation, you have to deregulate. And so I appreciate where you're coming from.
We also have evidence of people who are not lawyers who have seriously harmed people in the general public, especially in the area of immigration law in the state.
And I have a lawyer who's...
The court is going to be ready, just to be realistic,
Yeah.
the court is not going to be ready to
So-
steamroll UPL law.
So
I appreciate
can I jump in? Earlier today, Randy was doing the presentation of the sandbox, the regulatory sandbox idea that came from last week's meeting with Margaret Hagan and the folks at Stanford. And, it sounds to me like there is this, real challenge between, well, give me something that I know is going to, that's going to work, and we don't really know what works because we haven't had an opportunity to do yet. And so maybe the opportunity here is to offer as an alternative this a predefined regulatory sandbox where people get a chance to innovate within, from 6 to 18 months. They can create businesses, they can, provide services, and with the oversight and participation of the bar, go through a process where, they just play and try to figure out and maybe develop these alternative business models and ways in which maybe services could be delivered. And it would all be with sort of a, protection from prosecution. You're not going to go to jail. You're not going to get in trouble. You're not going to be fined, but we're going to create this. You have to register with us. I mean, maybe that is something this group could, define kind of the parameters around what that regulatory sandbox would look like and how that would work so that you could experiment in a way that was safe, but not, and then generate some of the evidence that I think you're looking for. But not necessarily mean that I have to be able to predict the future. I mean, as somebody who developed software, I really appreciated what she had to say earlier about sort of the risk aversion. I mean, it's hard to come up with an answer for every possible permutation of what might possibly happen. And sometimes you kind of have to do a little bit and then see what happens, and then you sort of respond to those circumstances.
Well, I think there's already similar things. I mean, the Global Legal Hackathon does exactly that, right?
Exactly.
They take a problem and then they attack it. But as a practical matter, why would a lot of these people throw their money into a project, just the sandbox, which would be very expensive? Like, I think the Global Legal Hackathon requires a lot of money just to be told 16 months later, sorry, nice try, but we're not going to actually change the law. Now you've really gone down a rabbit hole. So that doesn't sound like it would work to me.
I think there's a very important reason why
And Andrew
technology
over
companies might do that, and that's because they have the state bar's participation, which is really their greatest fear in innovating is prosecution by the state bar.
It's going to take money.
I don't know.
It's going to take money, but I mean, we develop stuff all the time that right now the State Bar of Florida, isn't always happy about the stuff that we create, but because we create it under their umbrella with money that they gave us to do so, I do think there are I do think people would be willing to walk Parkway down that path just to see, because you come back and say, we don't like the fact that it's blue. Then I come back and I say, okay, well, what if it's teal? Can it be teal? Can it be aqua? Can it be, cobalt? I mean, I think that's the thing is you keep developing. That's where you figure out how to refine it in such a way that it is responsive to the needs of the court and the needs of the bar and the needs of regulations, but also is,
You're working
innovative.
with the state bar.
Yes.
Having that conversation.
Yes.
And if you're with the state bar and with the court, the regulation becomes moot because they're a decision maker in the process.
And at least you're protected from going to jail or being fined $1 million or getting yelled at,
And
right?
it's not having outside of the court or the state bar's view. That's the problem. If you completely remove the rule,
Right.
then it's almost impossible to find the bad actors who are harming people. The sandbox, I think, is an interesting idea, not only because you can see what kind of technologies might develop, but you can see the kind of rulemaking that you can build around that, because you're never going to get away from having a rule to protect the public and the administration of justice, which protects the public as well.
Well, and
One of the fears is that you overwhelm the system with cases that really don't belong in court, and that prevents meritorious cases from ever coming to the court. So you don't want to choke the system because that's also a form of protection.
And I think that is something that a lot of the sort of the access to justice focused online properties, whether they're websites or applications or whatever, part of their job should be to say, wow, you've got, to help weed out this is not really going to be something you're going to be able to do. I mean, in Florida, if you're evicted for not paying your rent, you get evicted whether you were not paying your rent because you've got rats and cockroaches, forget it. It doesn't matter. I mean, if you didn't go through the process properly, that's what the law is. You still didn't pay your, there's no reason for that to ever go to court.
So everybody, I'm sorry to interrupt. As has been mentioned many times, we're under a tight timeline. We've used over an hour. We have 30 minutes left. We are tasked with drafting a report, having reviewed the rules that have been assigned to us or identified by us at the first meeting. It would be great if, I'm sorry to take over the chair's role, could we just start going through this list? We have to get this in narrative form by the June meeting, and it is our responsibility to review these rules. The sandbox issue, very interesting, is probably a group decision, not this subcommittee's decision. So let's just start getting to work.
So first of all, for the next rule, I want to let Lori and or Alan pick the rule that you want to tackle. If you don't have one you want to pick, I have some things that we can go after. And in the meantime, though, I do think it's important that State Bar the staff know that I think our whole group has been sort of in this frustrated position, wondering what the other groups are doing, because that will certainly have an impact on how we look at each of these rules. Right now, we're looking at them in this vacuum where there's no fee sharing, there's no other attorneys that we're partnering with, and I think that's why we've ended up having a lot of hypotheticals, but we could invest a lot of time in these hypotheticals and then as a group come back and say, no, we're not actually gonna propose fee sharing. We think that's a terrible idea. So I just would say, moving forward, I think that would be incredibly helpful if we as a whole group started focusing on which direction we anticipate going, because our decisions are going to flow from that. So with that, do you have a rule?
Well, I think based on the amount of time and the makeup of what I perceive our task force to be made up of, I would want to start with Rule 5.4, which is fee sharing.
Okay.
But I would also defer, I don't think this should be the Lori show, so I'd love to hear what everybody else thinks is the first one to approach.
I'll second that, absolutely, yep, 100%.
What are you seconding?
That we hit that rule. I mean, that's one of the core things that was part of the charter that brought us in here, is that you've got examples of people that are non-attorneys coming into a lawsuit to invest in the outcome, and that investment might very directly affect the thresholds by which they'll choose to settle, which has nothing to do with the people that were hurt in a supposedly valid suit.
Okay.
And I think it ought to be opened up. Heck yeah, let the investments come in.
So I'm agreeable. I can't remember. Is another section sort of tackling this? I think there's some overlap.
That's
But I think we should.
Alternative business structures, multidisciplinary practice.
But I think we should have it anyway, so that we know sort of what our group's thoughts are on it, going into the larger one. I'm with you. Open it up. I think anybody can share fees. Is there anyone who disagrees?
Me. It's a horrible idea. No, it really is. It's a horrible idea.
Really?
I really honestly think both sides of the coin are entirely possible, because if you say you have a banking firm who we all know has less soul than attorneys, comes in and says, okay, you've got a group like Aaron Brockovich where you've got 1 million defendants, and we know you're going to get something because you're going up against BP because it's another oil spill, and what we're going to do is give you $1 million, but we're going to take first place. So now you got the attorney taking 33 and a third, plus expenses up front, plus you've got the bank's going to maneuver for first or second position. You're putting the plaintiffs all the way to the to the back end of this. And then you're going to do exactly what, or the bank's going to do exactly what an attorney's going to do, which is whatever the offer is that covers their investment, they're going to come in and say, yeah, absolutely, you should take it. And then the plaintiffs are going to say, well, I don't know. After we pay the 33 1/3, then we get the $1 million plus the interest on that and whatever expenses were there. There's not going to be anything left. And then the bank's going to have the position that they can say, well, we advised you to take the deal. We lost later on, but now you're liable for what our investment was. So I think it's a horrible idea.
So banks cannot be, no fee sharing with banks.
Insurance companies,
No fee sharing.
individuals,
Well,
venture
I
capital.
think that's a consent thing. So I'm not sure I agree wholeheartedly that should never be allowed. I think that there are portions of the rule that are important. One, keeping lawyers, lawyers should not be influenced by those other groups. I think it's important that lawyers maintain their independent judgment. And I think, so I don't think we should just totally do away with Rule 5.4. I think that fee sharing should be allowed as long as lawyers maintain their independent judgment and the client has full understanding of who's getting what going into the agreements. As long as the client consents, for me, it's always client consent. We allow the client to decide what they're willing to agree to and partake in. They have the ultimate choice. So for me, it's informed consent, and lawyers shouldn't be influenced. I think that'll be.
I have one comment, and then Professor Moore, which is that I don't know how bringing the banks on board, because an attorney can go get a bank loan,
right,
and there's litigation loans. So that's kind of something that already exists. Like an attorney already has access to some capital, or you join up with other attorneys for pursuing a litigation. And I think in that case, either you're just getting a loan out of the bank, or you're partnering with another team of people who are looking and making an assessment. No firm is going to come in on a personal injury when they don't see potential recovery and potential wrongdoing. So you have people that know the area of law and can vet it. And the other thing I want to say is that, let's take the advice we were given by Greg and also continue to think about specific examples. And I think earlier we talked about innovation, that, Lori and I can partner, and I can be an attorney and she can be the tech person, and we can fee share so we rise or fall together. And I think for me, that's also a number one example.
Okay, a few points. First, I'm glad Lori mentioned the professional independence of a lawyer, independent professional judgment, because in the ABA, the name of the rule is professional independence of a lawyer. That's Rule 5.4. We more accurately describe it as financial and similar arrangements with non-lawyers, which is what it's all about. Ultimately, what's the goal of the rule is to maintain the professional independence of the lawyers who are representing the clients. As to loans from a bank, a loan from a bank is going to generally be made at a fixed interest and will not be a percentage of the recovery. So we're talking about something completely different, I think, under those circumstances. Another point, this Rule 5.4 is also protecting against people who open a business. They're just going to go out and essentially bring clients, identify clients,
exactly,
send them to the lawyers who are willing to pay them the highest percentage of a fee split. So I'm not saying to just completely discount the concept of splitting fees with lawyers. I think that there might be some benefits that can be derived. I still haven't seen them yet, but I think there might be, having these multidisciplinary practices. I think that Randy sent around a 2015 memo where that hadn't actually been observed. I think it was Australia or the UK, I forget. Australia, they hadn't actually observed any benefit from having a multidisciplinary practice structure. I like the idea of exploring it, but there are, this rule's been around a long time, and the downsides are quite large. To just say do away with the prohibition on fee sharing with non-lawyers, I think we have to tread very carefully. And part of that is, yeah, granted, I'm a lawyer, I'm risk adverse, and I'm talking on behalf of the public in this case.
Okay. Alan and then Joyce. Thank you.
I agree we should open it up. I think there should be rules about disclosure. So like know who's participating in that benefit. I would say to the point that you make about selling off customers to the highest bidder, lawyers actually do that now, right? We actually ran a personal injury campaign for a particular firm up here in the Bay Area that claims to pay the highest percentage of referral fee to other attorneys that refer them their personal injury cases. So, but nothing about that experience. They're actually a better firm, right? They're really good at it, and nothing about that experience, to my knowledge, is adverse to the public interest. So, I think as long as everybody's very transparent, it's full disclosure. I don't find a problem with it. Just my general opinion.
So in terms of, and this is a question as much as anything else, if I as a tech company hired a lawyer and I built some online tools and the lawyer's job was to ensure the accuracy and veracity of those tools, you know, in terms of being compliant with current legal whatever, does that violate Rule 5.4?
If the payment is based on the fees that are received.
Okay.
So if it's just salary, not a problem, but if it's based on, you know, selling it to clients and getting their client payment, that would constitute fee sharing.
Okay.
Yeah. So 2 points, and then Lori. 2 things something that I heard earlier on, not this meeting, but earlier on in the task force, was the idea of potentially limiting the fee sharing to certain professionals. So I'd like your thoughts on that. And second, something that is on the agenda for today, which would be holding law firms liable. And so I also ask you to consider that if Lori and I are in business together and she knows she's, you know, joining up with an attorney, that maybe her liability is now, her and I are going to share equal liability, whereas if she left me out of it, maybe she wouldn't have that same type of responsibility, but maybe also not the benefits. So I want your thoughts on that too.
So I'll respond to those in a second. I wanted to go back just for a minute and sort of reflect on what I heard, and this may not be what you said. What I heard from the court, not the court, but from Greg, sorry, and what I heard from Kevin Moore. I heard we can't just do away with the rules because we are in charge of protecting the public, and if we open it up to all of these other people, there will be bad actors, and lawyers are charged with protecting the public. And then from Kevin, I heard.
That's not what I said. But
okay. Well, and again, I'm paraphrasing very badly, but there is this idea that lawyers are the administrators of justice. I think I can maybe use those words differently. So it's important that lawyers are in charge of justice because they are the ones who are going to administer it the best. But then we hear from Kevin where this idea is if we fee share, they might be influenced by these non-lawyers, and we have to be careful. And that feels like kind of having your cake and eating it too. Either lawyers are in charge and they are in a better position, they're more educated or they're more trained to identify these problems and make sure people stay out of trouble. And if so, then there should be little worry that they're influenced by these non-lawyers because by definition, they're better trained, they're licensed, they're better educated to handle keeping out of problems because you've locked down the system so no one else can provide them anyway. So it feels very duplicitous. I can't use that word because I can't pronounce it.
Please don't.
I'm saying that from, I don't actually believe that is the problem or the process. It's just what I hear sometimes when I put on my consumer hat because I'm not a lawyer. So I would share, I've had plenty of bad acts by lawyers in my own life, and in fact have a lawyer who just got disbarred and stole $2,000 from me. I'm a very well-educated consumer who's been in the legal field for a long time, and I got duped by a bad lawyer. So those things happen to everybody. I just want us to be careful that we don't say on one end, from the standpoint of only lawyers should be making these choices, and then we go over and say, okay, well, let's do away with the rules so we can partner, that we also say, but if we partner, then lawyers are going to get influenced by these bad actors, because I feel like that's kind of opposite perspectives.
Okay, good. Just, Rule 5.4 has 6 separate paragraphs to it. So there's 6 different concepts that are addressed. The first deals with, only paragraph A deals with fee sharing. Other provisions deal with ownership, being in a partnership with an owner, and so forth. Let's focus on just what we're talking about. If we're just talking about fee sharing, that's just going to be paragraph A. If we're talking about, if we want to go beyond that and also talk about forming a partnership with non-lawyers, that's the multidisciplinary practice concept, or ABS, alternative business systems. Or if we want to talk about non-lawyer ownership of a law firm that is providing legal services, then we can talk about that, but we should talk about them, I think, maybe separately so that we don't cloud the issue. So let's just talk about this concept of sharing legal fees. And part of the reason is California has traditionally had what might be called it's called naked referrals, bare referrals, that a lawyer can refer a matter to another lawyer, get a percentage of whatever fee is earned, without doing anything beyond the referral. All you have to do is refer. In the American ABA rules, and which have been adopted by most states, there may be about 10 or 12 jurisdictions that have a rule similar to California's. Most other jurisdictions have the ABA. You either have to participate in the matter, and then you are entitled to a fee that is proportional to the amount of your participation after you've referred the matter to another lawyer, or you assume joint responsibility, which is not defined, but everybody just assumes it means you assume malpractice liability. If things go south, the client can sue you as well, having referred the matter to the other lawyer. So in a way, it's kind of the word that you didn't use, but I think you started to use, duplicitous, that lawyers allow themselves to share in fees, but not allow non-lawyers. But the other thing is that part of the lawyer's duty of competence is to refer matters out when you know that you don't have the expertise to handle a particular matter. That's one of the options. You have 3 options. You can study, you can learn, and acquire the expertise. You can associate with another lawyer and cooperate with the other lawyer in providing legal services, or you can simply refer the matter. That's explicitly stated in the competence rule. And the theory is that lawyers, because of this duty of loyalty that they owe a client, the duty of fidelity that's owed to each and every client, will look out for the client when they're referring a matter to another lawyer. Now, I realize that isn't necessarily what happens in actuality. It would be nice, but that is the theory. With a non-lawyer who is referring a matter to a lawyer, that's the aspect I gave to you. Yeah, that's one way of sharing in fees. Another way of sharing in fees is where you have a litigation funder coming in and funding the litigation with the promise that they're going to get a percentage of the take of the judgment, or perhaps a percentage of your legal fee. Because remember, the thing that you have to keep in mind is that if a lawyer is charging a fee, if it comes out that the lawyer and the bank together are taking 2/3 of the fee, the problem with that is we probably held to be an unconscionable fee, because we have another rule that prohibits an unconscionable fee.
Also, in fee sharing, you can't charge the client more than you would have charged them in the first
Right.
instance. So you wouldn't be able to charge 2/3 unless that happened to be your fee agreement. You'd still be limited to a 1/3 recovery.
But most of these are designed around contingency fees, correct? Like what we're sort of not addressing is the idea of fee sharing when you're dealing with something that's more mundane or is hourly billed or flat fee differently than contingency. Litigation funding already exists. I know that already happens in a lot of places. I envision possibilities where there are cases where you need a specific type of expertise or maybe an overabundance of document preparation, and you could partner with someone who had that expertise, a non-lawyer who does that and can do that. And I see very little difference in that on the small case side as I do in Big Law, where Big Law has created all of these smaller ABS models so that they can pay less money. So our big corporations have already solved the problem, but we haven't really done that at the level where I think access to justice needs it the most, clearly the smaller levels. So I'm not really thinking about litigation funding because I think there's already a model for that. And fee sharing between lawyers, I have trouble understanding the difference between a lawyer turning down cases from someone who refers them to them from a non-lawyer and a lawyer. That should be the same process for the lawyer accepting the cases. They have that they're bound by their duty and their loyalty to the client. And all I'm suggesting is by eliminating the idea of fee sharing, we allow more people to connect in places where lawyers are not connecting as it is, because that's really what we hear over and over again. People who need help are not going to lawyers. So how do we build better?
There's 5 minutes left. I wonder if maybe we could take away something from this discussion I might be getting out in advance of where we are, but I wonder if there might be a majority or consensus amongst the group as to whether or not, and agreed on the comment previously, we don't know what the other subcommittees are recommending, so that causes a little bit of a problem for us. But I wonder conceptually, there's a lot of talk about whether amongst this group, but whether the rule should be revised to permit fee sharing with non-lawyers. I wonder if it might be appropriate to take the temperature as to whether or not we should, the group would recommend fee sharing with non-lawyers, with any non-lawyer, or if a subcommittee recommends that there's some form of regulated entity that goes through some other approval process, and it might be comprised of non-lawyers themselves, if there might be a recommendation from this group to modify Rule 5.4 to share fees with that type of entity.
I don't think that we have had a chance to discuss it anywhere near well enough to have any sort of conclusion.
Yeah, and I want to ask one question because this goes back to what Greg said earlier. How will elimination of the prohibition on fee sharing increase access to justice?
Well,
in terms of the fee sharing with, not between non-lawyers and lawyers. That might be that you might bring some people into a connection with lawyers, but couldn't you accomplish the same thing by educating the public without?
Well, consider the apps that she showed earlier. You could have an app that then says, stop, you've reached the limit on our apps. We're going to send you to an attorney. And part of their revenue could be, if the attorney hires that client, could be to offer payment. Right now, that would be one example of something that's limited.
But if that's a flat fee, is it fee sharing?
No, it's not going to be a flat fee anymore. That's the point. Because now we're not talking about going out and finding a client and pass them off. We've got social media. I can go find you 1 million clients. Then I can come to you and say, how much are you going to pay me, and how much are you going to pay me, and how much are you going to pay me, and then I can choose.
See, that's what we don't want. We want you to choose the attorney who can handle it the best.
That's why I'm strongly against opening this
But
up.
I'm actually not just suggesting attorneys either. I'm suggesting ownership. I know we haven't had this. I think, Andrew, because of the time factor, if you're asking, I don't know if anyone else here is ready, I would make a formal recommendation on my side, a motion that Rule 5.4 be changed to allow fee ownership allow fee sharing between lawyers and non-lawyers, provided there's informed consent and there's still discussion within the rule about keeping the lawyer, keeping their professional judgment independent. And I would also make a motion that ownership of legal services be opened up to non-lawyers. So with those same ideas intact. I don't know if the group wants to try a vote on
Without any
that to see
regard
where
to
we are.
profession though, right?
Say that again.
Without any regard to profession, meaning you're opening it up completely, not regard to, yeah. Okay,
I'm not
perfect.
suggesting an entity, a group of entities or regulation that is defined by some other group. I'm saying for purposes of my recommendation, it would be that Rule 4.4 be changed to allow fee sharing and ownership between lawyers and non-lawyers, with lawyers having the, lawyers maintaining their professional independence and clients always having informed consent of what those fee agreements look like. And
5.4, yeah.
Are we, when we come back, is it going to, do we need 2 hours as a group when we come back? I just want to.
Plenary session begins.
Okay, and it'll go till 4:30? Okay. I just want to make sure, because I know earlier we had a discussion that this morning, we had a discussion that there might be some flexibility in the scheduling, so I just want to make sure we are using our full time and that it
And
be
we need to
adjusted if
discuss questions.
necessary.
I haven't heard that it's changed.
Okay.
We could start late. I mean, yeah, you're right. It may go, we could go longer, but we can't reconvene under the Bagley-Keene rules.
The subgroup can't reconvene?
Not today.
Change that one.
We could go late. We could start the plenary session at 3.
Right, I guess that's what I'm suggesting, to make sure that if Randy doesn't need to discuss the survey again, if he does, because earlier he just wasn't sure whether he'd need to discuss it later or whether he'd do it earlier, and we did make time earlier. So if he doesn't, I just don't want us to get out at 3 o'clock or at 3:30 and have a whole hour unused.
Right. I will, yeah.
Question, what if as an assignment between now and next meeting, every member of the subcommittee can comment or propose on each of the subsections of 5.4 and make a recommendation? That way we would all have time to evaluate everybody else's input and maybe be in a good position to
They're coming back.
make a motion or take a vote early at the next subcommittee meeting.
Great idea, Andrew.
Just trying to save time.
Yeah. Okay, so let's do that, but also, Lori and anybody else, please put your comments dissenting directly in. I think the Word doc was circulated. You can do it the way Andrew did it. You can do it a different way. That was just one option, and to put your thoughts in. But it can be, it can be whatever you want it to be. Don't hesitate, but it needs to be broken down. I asked that it be broken down rule by rule, so that way we can process it similarly. And I know it's hard to get this done, but the earlier, you get it, then the earlier everyone has to process. But I've tried myself, and it doesn't always work out that way.
Okay, just for some clarification, are there any other rules besides 5.4?
5.5? I would suggest 5.5.
Okay. And I'm looking at 5.4 and 5.5 in the memo on page 10. It says to be completed by other subgroup.
Well,
but we're okay on that. We're addressing it.
Really good.
And keep in mind, here's a problem with 5.5, is because it's very limited here in California because we address the multi-jurisdictional practice, that is other lawyers from other jurisdictions coming into California to practice. It's done by a rule of court rather than by rules of professional conduct. That's why our Rule 5.5 is 2 paragraphs. The ABA rule is 5, with numerous subparagraphs in each one of those other 3 paragraphs. The other thing to keep in mind is that you can't address UPL simply through a rule of professional conduct or the rules of court because it's statutory. So it has to be addressed by statute. So given our amount of time, I'm not sure that we should try to tackle Rule 5.5 right now. But we'll keep it in mind and try and come up with some ideas. But it's going to be real difficult. And let's see what the UPL group has done.
And I think that it would be important to, depending on how it goes this afternoon, just to get down your thoughts so that we have a general working base, so we kind of know what each other is thinking. You know, I think even in this short period of time, you know, Lori, you threw that out there, but a lot of us are kind of like, yeah, I mean, it needs to be further vetted, but yeah, we're kind of on the same page, big picture, but you know, we all recognize that there has to be, you know, some of the pieces of the puzzle need to stay there. And so I think just getting ahead of these issues will make it easier to address them.
So is the idea that the subcommittee, each member should go in and make specific comments to, starting with Rule 5.4, but do we want to go ahead and do that for all of them? And then see if we have a consensus on some of them before the next meeting, time-wise?
So Rule 5.4 we had not tackled yet at all, so.
Oh, I'm sorry, is that,
No,
which one we were talking about today?
You're correct.
Oh, yeah,
I'm
okay.
saying we had not previously tackled it.
Okay.
Yes, but I do think for all the other rules that are in here, which are rules that are more related to these bigger pictures, those everybody should continue to review and to put your thoughts into all of those other rules. I think that's sort of an ongoing task that as we continue these discussions, you know, if you didn't get a chance to do it before, do it now and recognize that just build from here in this format. That way as we go through it, we can continue it and add to that 5.4.
Okay, our next meeting is May what? Because I want to suggest a date by which we do this. I think that might be helpful.
Can we do this in a Google Doc?
No.
No.
If we wish. The 13th, May 13th in LA is the next meeting.
Okay, so today's the 8th, at 14 days gets us to Earth Day.
I don't know when Earth Day is. So the 22nd, the day after Easter?
Okay, we'll do it the Friday after Earth Day.
So the 26th?
Yeah, the 26th. Let's aim to get the comments. I'll try and get my comments on 5.4 out earlier than that.
So get comments to 5.4 by April 26th, is that right?
26th, correct.
Is it just on 5.4 or all?
You know,
Well, 5.4 plus the ongoing. It should be in there that the other rules, not 5.5, but the other rules that are in the memo, that they should continue to revisit. I think that should continue to be part of the assignment.
I think the next meeting may be our last before we have.
Yeah,
Yeah.
it is.
Yeah, I'm with you, Mia. I think we have to, I think whatever we need to say, we need to get it in there by April 26th so we can discuss maybe any of the larger issues at the next meeting and come up with our consensus. Is that
Yeah. I just again ask that it be in this format,
Yeah.
so whether you redline
in the
or-
memo itself?
Mhm,
Correct,
in the memo
yes.
itself, yep. And I think it's also fair that, given the time, we also need to consider hypotheticals. And I think my intent, but I can't remember if it's what happened, is that's how it's broken down. What's the impact? So the idea of this breakdown was public policy issues, okay, that's why it exists. Then my intent for paragraph B was, how does this apply if we're only talking about attorneys and nothing changes with regard to UPL, multidisciplinary structures, and those other ones. And then C would be what needs to change if these other things are revised, which we just don't know, what that's going to be. So that's the intent of the breakdown between the A, B, and C. I don't know if that was obvious. Probably not. Any other comments?
This is why I love this. That room is where I play.
What, my breakdown?
No, my business. While we're debating all these signs from one side to the other, that's where I make money.
You just kind of hide
I just steamroll right through.
I thought you were going to say you flow between the interstices of the law.
Are we on a break? Yeah, I think, are we on
We're on break.
Yes.
Can I quickly ask, had to go to the other subcommittee meeting, what was the upshot of the 1.1 comment?
We're
So,
gonna steamroll right through.
Yep.
yes. No, we're keeping it as it is. We just had a discussion, that we'll make sure that the process is clarified, but we did as a group decide what we decided. We're gonna keep it, and we discussed all the opportunities that there are going to be for, sharing other opinions, which are welcome.
So is it going to be brought forward to the ADLs this afternoon?
I don't know. We asked when that would be the right time, and Andrew didn't have a good answer for us.
It could
said he
be
wasn't
this
sure.
afternoon, it could be next meeting.
You tell us.
If you think there is that consensus now, I think it's worthy of, at least we got something to move forward on.
We are keeping what we have. So yes, we can go forward.
Let me just make sure. Okay, so we could under C2B bring it forward if you wanted, if you felt it was ready for discussion. It would have to be presented, and it comes as a recommendation from the subcommittee, so I don't think it requires a second when it gets to us. It can be a call of the question after discussion. But it's up to you guys.
I'm sorry, I don't understand.
I think he's suggesting that it's adequately noticed.
It's adequately
If
noticed.
you wanted to bring it to the group today.
You can.
and to vote on it, you could do
Yeah.
that.
So the group would just, so the motion is for whether our committee wants to vote in this rule, this comment?
It could be as neutral as there's a consensus on the subcommittee that the ADL's tentative report include a recommendation that the board consider amending the comment to California Rule 1.1 to include
Okay.
a reference to professional responsibility to be competent in technology, and that there is an illustration or conceptual draft that can be shared as well. And it's really, at that point, an item for debate for ADLs if they want to include that in the report. And, these aren't implementation recommendations. They would go to someone else to consider the implementation recommendation of the board. I don't know, it might go to COPRAC to discuss. If the board says, we agree that there should be this comment, we'll, have COPRAC start working on.
And I can share the other positions that my committee took.
Yeah, in fact, you can invite anyone on the committee to speak to the recommendation.
Okay, yeah, I think we're as ready as we're ever gonna.
Okay.
We're ever gonna
It's
be.
good. It's good to have one.
Okay, I think we're going to go ahead and get started and have the reports from each of the subcommittees. So, do we need to do another? Okay. We're going to start with another roll call.
Okay. Justice Inman.
Here.
Toby Rothschild.
Here.
Joyce Raby.
Here.
Andrew Arruda.
Here.
Siam Boni.
Here.
Tara Bird.
Here.
Judge Wendy Chang. Abhijit Chavan. Jean Clausen. Johan Droshagen.
Present.
Margie Estrada. Lori Gonzalez.
Here.
Bridget Grammy.
Here.
Andrew Kuchera. Joanna Mendoza. Kevin Moore. Heather Morse. Daniel Rice. Alan Rodriguez. Dan Rubens. Mark Tuft. Joshua Walker. Thank you.
Okay, thank you very much, Mimi. The first subcommittee on the list is UPL AI, and Judge Chang, are you going to report out?
Okay, so we first talked about our agenda items, and then we went to talking about responsibilities for the draft report that we hope to have ready for review by May. The first item on our agenda, we talked about the LCCA standards in the cloud computing, and whether or not we thought we should just adopt those as the privacy standards that we would be using. We didn't have a quorum, so we didn't vote. But we were all in agreement with Abhijit's recommendation that we use it as a reference point, but not that we wholesale adopt it. We felt it was, on the one hand, it was a little bit very much vendor specific, and also it's probably better for the bar to retain control over that in the long run. It's more flexible. Heather Morris provided a report on the types of privacy standards that are being required by for law firms to comply with. And in the context of that memo, she actually had a lot of the types of things that law firms are being required to do to comply with the privacy standards by the clients. And we're going to take that data, we're going to fold it in to the final report. Then we talked about, and we spent a lot of time talking about the OPC's request that we analyze the medical device advice process by the FDA. And we did talk about it. At some level, we came to the conclusion that it's not directly analogous, but it is somewhat. Legal advice is not so device-based as medical services are. And so in terms of the wording of that, that's a very minor point. Then the question was whether or not we were talking about the regulation of the actual providers themselves or the actual software product that they were offering. And we had a long discussion about that, and we came to the conclusion that we believe that it should be a hybrid of the two. So we would be looking at the specific software products, and in the context of reviewing that product, the providers themselves and their privacy standards and what their internal processes are will be evaluated as part of the software's certification process. But what we are not doing is certifying providers wholesale. It's going to be product specific, and so it's not, if one provider provides like 10 different types of products, they would have to get certified for each of the 10 for it to be, because I think it's too malleable and it's too potentially changeable, and it's very much less public protective to just certify a provider without regard to what services that they're offering. So then we thought about it is possible for the software to be delivered on different types of hardware, and that it actually can make a difference. There's more security involved, more security and privacy protections in certain devices over others. And then we thought if that was the case and the product was capable of being used on a less secure device, that there must be a disclosure given by the provider about the less protection that would be offered in that kind of process. So then we talked about whether or not, how will we certify? Are we going to use a different type of competency standard, meaning less competency required for simpler programs, or programs that I think were less risky. And we decided that no, we thought that was not very public protective and that it should be a single competency standard. But we would, I think, acknowledge that complying with that standard may be less depending on the type of program and the type of risk involved with the type of service that the program is offering. Then we thought about tiered regulatory approval process. The FDA does have different tiers of regulation, and we kind of superimpose that on the types of services that come in the legal setting. And the first one is just pure legal advice. Well, is it legal advice? And if it's not legal advice under the current law, it's not considered UPL. So these are like scriveners and like forms providers and stuff of that nature. And the question was whether or not we wanted to fold that into the regulatory process that we are going to be recommending. And we thought the answer should be no. That would be overcomplicating what already exists, and there's no need to do that. I think we thought it was going to be complicated enough already without adding that additional level of regulation. It might be a little bit of an overreach. The next category would be products that were exclusively provided to lawyers and law firms. And in the current law, again, if it's being provided through a lawyer or a law firm, that again is not considered UPL. So then we asked again the question whether or not we thought we should extend the regulation to that category. And again, we answered the question, no, that it's not necessary to do that. That already exists and it's working just fine. So we wanted to limit what we were doing to the software that's being provided directly to consumers. And we had a little bit of a discussion at the end of the session about how current law says that business entities that are existing as separate entities, then they're even if it's a small business owner, it might even be a one-person business, they cannot appear in court in their own name under the current law. And we acknowledge that under this contemplated systems, those businesses will continue to not be able to appear in court under the current law, and that we understand that what we are proposing is going to be really directed toward the individual consumer user. And then finally, we talked about that's how making recommendations to how the state bar would what they would use to analyze the competency of the specific programs, and that we would kind of tier it based upon the level of risk that is going to the consumer. And it's not going to be based on the type of service, like transactional versus court or administrative court. We decided not to do it that way, that we would be recommending it based upon the level of risk to the consumer of what the outcome would be. So criminal, custody, wills and trusts, stuff that have really big impact would be on the highest end of the risk spectrum. And then we said at some point, at a final point, if it got to the point where judgment was really going to start to be involved, and it's going to be it would require the discretion of a decision maker to make a call. You know, as I think somebody said, I don't remember who it was, the computer version of it depends, right? So when it comes to the it depends answer, it no longer falls within this structure, and at that point in time, the computer is going to be required to say you need to talk to a lawyer. That the safe harbor is not going to extend that far, and that was the extent. And then from there, we started talking about how we were going to split up the reporting, drafting responsibilities. And so I'm going to take on the regulation of the practicing of law, that requires the definition of the practice of the law, and restrictions for UPL. And we decided that we were going to recommend that California retain its current approach and not leave the definition of UPL the way it is, which is very, very broad. It's not really codified specifically in a statute. Well, it kind of is, but it's not really. And it's very, very fact specific, and it's purposefully that way. And we decided that given the vast number of fact patterns that UPL can arise in, it is better to keep the definition broad, so it's more malleable to those types of circumstances. And what we are recommending is that we add an exception to the prohibitions against the unauthorized practice of law that provides a safe harbor to people who comply under the certification program. And that way, that allows the current protections to stay in place, and that we just carve out this little segment for what we are doing and what we are recommending in terms of the software certification. And then Dan and Simon are going to write the report on the regulation of an entity permitted to practice law using technology, and why it must include the establishment of adequate standards that regulate both the provider and the technology itself. And that's going to be the bulk of our recommended structure for the certification process. Then we get down to the regulation of artificial intelligence. Josh is going to write about federal law and California law approach to it. Heather's going to write about the purposes served by the regulation of artificial intelligence. Abjit's going to write about if the entity is permitted to practice law using technology, then the nature of the technology used should not be limited or restrained to any concept or definition of artificial intelligence. I think as a committee, we think it's very important that what we do is technology agnostic, that it's not limited only to artificial intelligence, because we felt that that could be too narrowing and that there was no purpose in limiting it that way. And if there's a provider out there that's not using AI, but is using technology that could serve the public, that they should be permitted to participate in this process. Abjit and Josh are going to write about if an entity is permitted to practice law using technology, then that entity should be required to provide adequate privacy protections similar to the privacy afforded to the attorney-client privilege and the lawyer's ethical duty of confidentiality. And then finally, Simon and Dan are going to write about if an entity is permitted to practice law using technology, then that entity should be required to provide adequate data security. And so it is our goal to circulate drafts within the subcommittee prior to the next meeting. So what you guys will get, hopefully, will be a streamlined version of our efforts behind the scenes. And that's it. Thank you.
Busy bunch. Thank you. So, others on the committee, anyone want to add to what Judge Cheng just summarized? Okay, folks outside the committee, any questions, comments? Yes.
Just wanted to know, in the discussion about certification, did you guys have a chance to discuss at all re-triggers for recertifying? Because you're talking about a per product basis for certification. Software products are changing all the time, so,
Yeah, so we're looking at basically anything that would be a substantial change to the software, but those are going to be very sort of specific. So it's okay to ship software daily without re-triggering the certification process every single day. But if you're shipping a major change to the software that would be worthy of a re-review, that's on the company to bring that up to the bar.
I also think that we're contemplating a faster process if you're submitting version 2.0 versus 3.0. It's going to be a simpler process than the initial process because you've already gone through it once.
It makes sense. That's a major, roadblock in software in general is recertification of future versions, which happens existing in other areas of technology.
Professor.
For what it's worth, the FDA came out with a discussion draft of a paper that I stumbled upon that talks about recertification, or where there might not be recertification of a software-based medical device. And they put out some proposals to avoid the recertification process because they recognize that software is changing all the time. I sent it to the in-house ADLS group, and they'll probably send it on to you. I asked that it be sent on to your group.
Thank you. Any other comments? Yes.
I'm just curious how we're going to integrate the different subcommittees. Again, we're running into overlap. Some of the things that were discussed in that committee were also discussed in ours, and we're not necessarily on the same page, it doesn't sound like. So I don't know how we're addressing that issue going forward as far as drafting things and so forth.
Randy?
So that will begin at the next meeting. The subcommittee sessions will become shorter and the ADLS sessions will become longer. And so the reason why we're asking things to be somewhat written up is so that we're not talking past each other. People, before we get to the sessions and we start conforming or exchanging our ideas or refining them, we'll have a better idea exactly what each subcommittee has in mind and can react accordingly.
Okay, further discussion. Terrific report. Okay, the next committee is Rules and Ethics. Tara.
So is now a good time to bring the motion forward?
Sure.
Okay, so we mentioned this after the last meeting, that we have a motion, and it's been circulated, but I'll read it. It would be comment 1 to Rule 1.1, which is competency, and the language that we're proposing, and then I'll get into sort of the different opinions of the section. Is the duties set forth in this rule include the duty to keep abreast of the changes in the law and its practice, including the benefits and risks associated with relevant technology. One other option was to end it with relevant technology in your area of practice. That's something we kind of went back and forth on. And some people on our committee thought that it should be even stronger, and it should be in the black letter of the law. Ultimately, we did not reach a consensus as to the black letter. We also did not reach a consensus as to that last phrase, in your area of practice, and we thought ending it at the word technology was sufficient. This is kind of a middle ground. It has a duty to keep abreast of changes, which is stronger language. And I know we're not supposed to be wordsmithing this, but we did, and I don't know how we would discuss it absent that. We also discussed whether the word innovation should be included, and we ultimately decided not to include it. And part of this was sort of a psychological thinking, is that by using the word technology in the rules, we thought it would have some psychological effect on attorneys to know that the State Bar is embracing technology, that we do all have a duty to, pay attention to what's going on, that we can't just close our eyes to it. In the other materials, you'll see we did research trying to find different cases where this might have been an issue. We didn't find anything really on point, but I think e-discovery would probably be a good example, that if you're using e-discovery, if that's part of your practice, you better understand it. Email is kind of an example, although we're all past that, but kind of similarly, that you need to be understanding how to use email correctly and security issues when you're dealing with your clients. So even though there wasn't a lot of case on it, there are opinions on it. It is something that is out there. So this is kind of a baby step, but it was the first step we could all come to some agreement on.
Mark.
Procedurally, should we be commenting before the motion is seconded, or should we comment now?
Well, there's a motion on the floor. Let's see if it's got a second.
I'll second it.
Okay.
Just to have a comment.
It's been moved and seconded. Mark, would you like to discuss it?
Thank you. So just from a drafting point of view, we don't really use the word your. I mean, you'd say in the lawyer's area of practice, I would think would be more consistent.
In the lawyers.
Keeping abreast of. I know this comes from the ABA comment to the model rule, and that's good ABA language, but it's pretty doggone vague. If it's going to be enforceable, you might want to think about how enforceable that is to keep abreast of, as opposed to things like being reasonably knowledgeable of, or to have a reasonable understanding. Reasonableness is a objective standard in the rules that most lawyers understand. I'm not suggesting the language change, but it just seems awkward to me. And at the ABA level, of course, this was basically a heads up comment. How actual enforceable it is, I suppose you could make some serious mistakes in e-discovery and the like that results in sanctions and what have you that would lead to discipline. I think that would be true, but I question, other than a heads up, that we should be aware of these things. I don't know how enforceable this would be. Nevertheless, I'm not against it. I'm just commenting on some of the language of it, that's all.
Just to share, another thing that we discussed was whether the state bar should have a mandatory MCLE for an hour, and we just decided as a group that was not really necessary, that there's plenty of MCLE out there already that discusses technology and innovation, but that would be something that could be enforced.
Judge Chang.
I just had a question. Comments are not the basis for discipline, right? Only about rules violations, is that correct?
That's correct, but the way this is written, we took it from current former rule 3110, which was that was the number of the competence rule, and this is the exact same phrase that was used in that rule. All it says is that it is interpreting what the rule includes.
Okay. It's my opinion that this is already the standard in California, because there's at least 2 ethics opinions that set forth something, language very similar. So I don't think it's going to be, I think it gives more of a heads up for people who don't even know what an ethics opinion is or how to find it. It's good. I think it's a good idea.
Yeah, and that also was something that we discussed, and also sort of came to the same conclusion as, reading all the ethics opinion is hard, and we wanted to bring it up in importance and value.
Okay, Mark, for clarification, you highlighted a couple issues in terms of language. Are you proposing any changes?
Well, you changed the one in the lawyer's area. I think it's appropriate. I think that I would recommend that. Keep abreast of, I haven't thought about it, but I would rather see it read something in terms of reasonableness to be, I just don't have the good words.
So the parenthetical in the lawyer's area of practice, that's not really the motion. The motion really ends at technology. But that other parenthetical was something that a lot of the group questioned, and so that's why we're sort of throwing it out there as well.
Well, that was my next question, since you were the one that moved it. Were you agreeable with the language? And I take it you're not. You would leave off the last parenthetical.
Well, my committee, as a group, decided to leave off the last parenthetical, but because it was sort of a close call, we wanted to make sure that this group also weighed in on narrowing it to in the lawyer's area of practice.
Okay, Professor Moore and then Judge Chang.
If I could mention one thing about the discussion we had at the last meeting, in the lawyer's area of practice might be too limiting in case the lawyer were to take on a new case outside the lawyer's area of practice. Then we're just saying more general application is if you're going to be practicing law, you're going to take on a case, you really need to be familiar with relevant technology or changes, advantages and disadvantages.
Judge
Yeah, I would agree with that. I think the parenthetical just invites games playing in the mind of a lawyer. Well, that's not my area of practice. Well, that's not. I think it really should be, if you're going to use technology, you need to use it correctly, period. And it shouldn't really matter how that manifests itself. I don't think any of the ethics opinions I've read across the country talking about technology competence, I don't think anybody narrows it this way.
Toby.
And I think to follow up on that one, beyond if you're going to use technology, but also if you're not going to use technology, you need to know what's out there and make a conscious choice not to use it.
Professor?
And last thing on the keep abreast of, I think this is slightly different than the ABAs, because the ABAs say a lawyer should, aspirational, and this is saying we're interpreting this rule to include that you have a duty to keep abreast of. So again, it's a compromise. It's compromise language. I agree. I'm not sure how enforceable it is, but we're at least alerting lawyers to the fact that they really need to be a little on top of things.
Further
I also can't think of any other words to use right now.
Kevin can't.
Yeah, that's right. If Kevin can't, then we're done. Lori.
I'll just point out that I'm not sure that our committee thinks this is going to increase access to justice necessarily through innovation, but was designed to help lawyers have a better understanding of their duties. So in terms of the, whether it should be a rule comment, we had a lot of discussions, not a lot of agreement. This was sort of an idea, but I don't think we have data to support this helps, and I don't think the idea was this is going to break open access to justice innovation.
Mark?
I read this a little bit differently in the sense that the duty of competence, covers virtually everything we do as a lawyer. As we've said before, it's a very base level. You can't compromise it. And as we move into the field of artificial intelligence and its availability, it would not surprise me that a lawyer who completely ignores the availability of technology that advances the client's cause and makes it more efficient, more effective, less expensive, whether that rises to a figure to be act competently, that's a question. But I think that's what we're saying to each other. Hey, look, technology is going to continue to advance, and you'd better be on top of it, and you better see how it best applies to satisfy your client's needs. And you know what? It may well be necessary. I know in the family law, many years ago, I had a case involving a family lawyer who did not use Dizomaster, and was sanctioned by the court because everybody uses Dizomasters. You can't. Well, I didn't know about that, she said. I'm sorry, but that's the kind of thing we're talking about here. Technology can reach a point where, you know what, everybody needs to know not only is it available, but you're going to use it. So I read that into the duty of competence. Not that you're going to be disciplined if you don't, but you better be abreast on what's on top of what's going on.
Tara?
Mark just made me think of something that could be similar, which is e-filing. It's spreading throughout jurisdictions, and what's cool about it is that you can file after hours, right? So now the deadline is midnight. So if you're not on board the e-filing train in your jurisdiction, you could blow a 5 o'clock deadline, and that could be a statute of limitation, when if you just e-file, you got like a whole another day of time to file that complaint. So I can definitely see examples like that. And then once you've done something by e-filing, then you can serve by email, and that changes a whole nother set of dates. And so anyone who kind of screws that up to the detriment of their client, I can see there being liability that this rule might actually step in and say, no, you should have figured that out.
And if not in a disciplinary sense, certainly in a malpractice sense. So I think it has a positive purpose to it.
Okay, further discussion, or are we ready for a vote? Okay, hearing no further discussion. Mimi, you want to do a roll call vote? A yes is, yes, I'm in favor of this being added to the rule and the parenthetical is out.
Yes. So the motion is to adopt the following language as comment 1 to Rule 1.1, and that's on the screen.
To be clear, it's as to the ATIL's recommendations.
Correct.
Yeah.
That's right. Exactly.
All right. Andrew Ruda.
Sure.
I'll just abstain.
Simon Bomey.
Yes.
Tara Bird.
Yes.
Judge Wendy Chang. Yes. Abhijit Sivan. Jean Clausen. Johan Drolshagen.
Yes.
Margie Estrada. Lori Gonzalez.
Abstain.
Bridget Grammy.
Yes.
Andrew Kuchera.
Yes.
Joanna Mendoza.
Abstain.
Kevin Moore.
Yes.
Heather Morse. Joyce Raby.
Yes.
Daniel Rice.
Yes.
Toby Rothschild.
Yes.
Alan Rodriguez.
Yes.
Daniel Rubens.
Yes.
Mark Tuft.
Yes.
Joshua Walker. Thank you.
Okay, thank you very much. Tara, you want to finish your report from the committee?
So we, like other that's been mentioned, that there's been a lot of crossover, and because the rules, it's kind of hard not to want to talk about other things. So we did start talking about Rule 5.4 and fee sharing, and we're going to develop that over the next month before the next meeting a little bit more. And the other thing, I guess, to help us out, since we don't know what's going on in the minds of the other groups other than these types of meetings, other groups to take a look at the memo that we prepared a couple months ago and to continue to build on it. I think we have a Word doc that circulated, and we'd love to hear how you think the
which rules in particular do you think your proposals would impact so that we can start already considering, get a little more insight into what's going on in your heads and so that we can consider that. And we're just sort of waiting to see what happens in the other groups. We'd like to move forward.
Mark?
Is this the right time to bring up the advertising rules?
Sure.
Is that in your bailiwick?
Sure.
Well, no one knows them better than Kevin.
I think that is part of our charge.
So you're, but you don't have any recommendations on that yet?
Not yet.
Okay.
Are you? Sorry. Okay. Are you suggesting going in the direction of the ABA?
Yeah, but not necessarily identical. I'm just saying it seems to fit into this commission, liberalizing the rules to allow for more advertising through technology is extremely important, and that was with the impetus of the ABA changes last summer, and I would think that would be something we'd want to consider. So I'm just wondering if that's going to be on the menu at some point.
We have it listed in the memo, and I can circulate the ABA materials to you folks, and then you can circulate them to the subcommittee.
And I don't suggest we do this, but there's a lot of material that led to that you can access to it. It was all driven by technology. All those changes, almost by and large, was access to justice and the more friendly use of technology to reach consumers who use technology to look for legal services. So I think it fits within our bailiwick to look at those rules.
Okay.
Okay, other discussion from the Rules Committee. Lori.
I just wanted to point out that I think that we are really not having enough time to really have discussions in our groups about these rules. We are going to be doing a lot of our discussion through point discussions in this memo over the next month, but I think I just want to kind of throw out there, Mark, I appreciate the idea of advertising rules. I'll share, I am very doubtful that I personally will have any time to throw any input or thought into that particular rule or most of the rules, because we have found as a subcommittee, it took us quite a while to get here, and I'm not even sure with this one rule that we really had all of the, there was some confusion in our subcommittee as a whole, or at least on my part. And so I just want to kind of throw out there, I think we've suggested as a subcommittee, we're going to focus on Rule 5.4 first for this next meeting, and then also try to look at the other rules. And so to the extent that anybody in the committee thinks we should also be looking at any other specific rules as a really heavy emphasis, I think that would be very useful to us to know.
Oh, go ahead, Randy.
Because you're formed as an actual subcommittee with its own noticed agendas, Mimi reminded me that you can actually schedule in between teleconference meetings. We just have to notice it 10 days in advance and have a quorum in order to hold that. So if it might be helpful, maybe not between this meeting and the May meeting, maybe between the May and the June meeting, if you needed an additional teleconference, and it doesn't have to be a whole day, could be a few hours, then that can be handled. We just have to notice it.
I think your point is well taken, Lori. Particularly because I had an opportunity to sit in on the ABS, and we're going to hear from Andrew in just a moment about that. And there are clearly some rules that they're going to be focused on and what they're talking about that are going to have to be addressed. So I think maybe, Mark, to the extent that you can suggest specific things that need to be addressed by the Rules Committee when Andrew finishes his report, it would be helpful, because I think we do need to be pretty focused. I know you've got a memo that lays out a number of rules, but to the extent weaving these committees together, we have specific ones we need to focus on, it would be helpful. Okay, further discussion from the Rules Committee. Or questions, comments, anything? Okay, then hearing none, Andrew, why don't you report out on ABS MJP?
So we had a very productive meeting. We ended up reviewing where we stood with we had 6 kind of working statements that we had been kind of iterating off of before. We ended up removing one and reworking another. So right now, our subcommittee is triangulating around the following 4 statements. 1, that lawyers in traditional practice and firms would stay under the current regulatory framework with a mind towards expanding access to justice through innovation. That last point there, with a mind to expanding justice, access to justice through innovation, was just that we may want to expand some of the things that are possible there. Number 2 was that we recommend that we widen the scope of our charter as a subcommittee to include entities which may not or may or may not have lawyer ownership or operational management and or control. The reason why we have that as one of our statements is we felt that although we are called kind of ABS MDP, it seems to be quite limiting in that those definitions are kind of set to include a lawyer in the loop in one respect or another, and we felt that we would potentially be kind of limiting ourselves, which is why we reworked this next statement, which will make that kind of all make sense, that these entities that we're talking about would be able to be composed of 100% by lawyers, 100% by non-lawyers, or a combination of the two. However, regulation would be required and may differ depending on the structure of the entity. The last statement that we have that didn't change from our last meeting was that the new model that we are proposing would include for-profit entities and would not be limited for not-for-profit entities. So just to kind of summarize those 4 points, what we're trying to say is that lawyers would, in the traditional framework, we would be able to work within that, but we are looking at a world and some recommendations to come around entities providing some legal services that would not be lawyers at all. And so that's something that for the entire task force as a whole, I think, is important to note. We ended up removing, for now, a statement that we had in place, which was that the State Bar would regulate these entities. And we may end up with that coming back in, and I'll touch on that in a moment. And we worked our last statement, which did have at a point where we thought each entity would have to require at least one lawyer in the organization for a quality kind of control aspect, but we ended up thinking that that might actually not necessarily be useful in this new reality that we're pushing towards. So we removed that. So those are the 4 statements that we're working with now. Other things we discussed that I think might be helpful to bring up for the task force at large is the idea of sandboxing a particular new way or ideas, and we identified what I've kind of classified individually here as the sandbox quicksand problem, which is that while sandboxes are great, and I think we're kind of innovating with guardrails, one thing that we worry about is that if we have a sandbox approach, we may not actually get the true market response needed. So if we want to push for investment or entrepreneurs to devote their lives to these new kind of entities, the idea that, hey, we're just going to be doing it, and that freedom from UPL issues may actually end up not being forever, may actually not enable kind of the market to respond in the way we want to. So we haven't really figured it out completely, but it's something that I think we discussed that I think might be helpful for all other subcommittees as you discuss kind of sandboxing in general. And another 2 kind of themes we discussed, which was if we are going to be moving towards a world where there are some entities that are delivering some aspects of legal services that are not legally, they're not lawyers, we're going to have conversations around fee splitting and advertising rules as well. In terms of what we're going to be doing for the meeting to come, I think the big question for us as a subcommittee is what does the regulation of those entities look like, and what will those entities be doing? So what we've discussed is that the non-lawyer entities may be able to perform the following type of actions. Those actions we haven't discussed, or determined, but that's kind of the framework we're looking at, with almost a tiered look at regulation where, if you do have lawyers involved in your organization in some capacity, regulation may change. And we also discussed very briefly the idea that we may be open to also including lawyers from other jurisdictions who may fall under that same umbrella, and that would be one of the tiers of these entities as well. So a lot of work to do, obviously, around that, the regulatory framework piece. But as a group, what we're all going to be doing is reviewing the 2017 LSC Justice Gap Report, looking at where there are particular highlights of where access to justice is particularly problematic. That is something we're going to be using in place out of the June release of the California-based report. And next meeting, we're going to be really focusing our time as a subcommittee, really trying to drill down on what regulation can look like. We understand that we're not going to be able to fix and propose a complete regulatory framework, far from it, but we do want to have some strokes and some kind of a skeleton, at least, that we'd be able to recommend. And so that is what's going to be done by us as a subcommittee ahead of that. Randy mentioned that we are going to be coming more frequently together between all the subcommittees, and one of the action items we have is that I'm going to be taking those 4 statements that we're kind of using as those key driving discussion points as our subcommittee, and I'm going to be taking and providing a little bit more insight into why and how they came together through a discussion of the pros and cons that come from each one, and that will be shared with the group and task force at large, so that when we do start coming together, folks will have a little bit of an insight into why we chose to kind of word things the way we did, as well as choose to highlight some of the actions that we want to get done. So that's the plan as it stands.
Discussion, questions for Andrew? Joanna?
One difference between our subcommittee's approach versus the UPL subcommittee's approach is that we decided trying to define what legal services are in the practice of law is just too hard to do. So this way we're focusing instead on how is the entity made up. Because if it's made up of just lawyers, you don't have to get into that. If it's a combination, you're addressing those issues through the regulation. And if it's same with non-lawyers, you don't get into any of those definitions and the problems associated with that. It was just how you regulate depends on how the entity is structured. So I'm not sure how those two things will eventually come together, but they're different ways of looking at it.
Daniel, and then Joyce, and then Mark.
So by the same token, I think we're planning to propose that the way you're regulated depends not on how you're made up, but on the things that the technology does. So I think it actually does fit together pretty well. I think we're taking the same approach. Just with different sort of substrates.
Joyce?
I kind of want to weigh in just briefly on the sandbox quicksand, because I think that's but it came up in discussion in the Rules Committee, and one of the things I think to think about is it's not a kind of pass-fail. It's an opportunity for the bar to be a part of the development of the thing that's being created, so that as it gets it's a conversation. It's an opportunity to refine, in detail. I think we're all sort of operating in the abstract, and the opportunity to actually see something being built, watch it be implemented, and then go say, okay, well, so now how would we maybe regulate that? How do we feel about that? What do we think about that? And be able to come back and say, well, what if we, we don't really like this part of it. Is there a way for us to constrain maybe this aspect? I think it's a conversation. I don't think it's a pass-fail kind of thing. So I think that's part of how you address the investment concerns, because I think people will want to invest if they think it's going to be a partnership where the goal is towards being able to implement something rather than a pass-fail. You build it and you do all the work, and we come in at the last minute and look at it and go, yeah, that's not going to happen.
I think that's a good kind of point. I think the challenge still for us is just ensuring that entrepreneurs, investors, et cetera, feel that it's not folks can't move the goalposts, essentially. Also, what we want to do is if we only have it in certain particular areas, one of the other things that was brought up is if we, for example, only focus it on areas that are, traditionally known as those ones where, there are the most challenges from an access to justice standpoint, we may almost be asking the technology industry to kind of provide us and help fix our problems without as much upside for them as well. So we want to make sure that we keep it as attractive as possible with the eye towards having certainty for those who enter the space that they won't have a situation where success is to be determined on 7 criteria, that the definition is kind of hazy, and then things can go south.
And it's similar to what happened with unbundling. Some states have unbundled a lot more, some states have unbundled less, and I think that's the same justification has been, well, family law gets unbundled because there's so much of it and it's never going to get addressed, and we're trying to make it as easy as possible, whereas we didn't unbundle stuff that lawyers felt like then you were cherry picking, right?
Exactly.
You were sort of taking the stuff that was easy to do.
Yeah.
So I think there's a lot more to that conversation.
Agreed.
I just think that we ought to think of it as being a more of a conversation where it gets figured out as we're doing it, as opposed to something where it's like, well, you invest all this money and you build the thing and then you fail.
Yeah. Well, what we discussed as a subcommittee would be essentially kind of a take on almost a sandbox, but it would be, you are able to do X, Y, and Z, but if you have any disciplinary kind of, issues, blah, blah, then but that's what we're going to be discussing with regulation. But at that point, it's very much an open, it's a pretty wide opening so that we can actually gauge and have the market respond in the truest sense is what we're hoping to accomplish. And ways that we can kind of build things in is what we were discussing, is that we might have, certain, you're free of UPL issues for 15 years or whatnot, and then we can reassess, whatever that may be. But we're going to be working hard as a subcommittee. That being said, if anyone else comes across articles or information that would be helpful as we kind of embark on this journey around trying to figure out regulation on this, that would be helpful as well.
Lori. Oh, I'm sorry, Mark. I had called on Mark first and then Lori.
Yeah, I thought it would be useful to take just a moment to talk about the entity regulation debate we had, discussion we had. When I did my memo on law firm discipline and then morphed into entity regulation, it came clear to me that some of the objections to law firm discipline are going to get carried over into entity regulation. And the one that I thought was most important is that by regulating an entity as opposed to its members, there is the risk of just transferring the business model to the new entity. If you decertify or deregister the offending entity, people move on, and they're not accountable. And you can have wrongdoers that commit some pretty serious harm that just move around, and that gets even more pronounced when you have multi-jurisdictional entities. And the ability to, and then here's the reverse side of it. The reverse side of it is you have an entity that violates the rules and regulations in a state in which they're licensed, and that has all the negative connotations to it. And you got people who are highly talented who aren't even practicing in that jurisdiction. They're over in state B, and they got to carry this stigma with them, and that's not fair. So those arguments that were advanced against law firm discipline are going to come up again. And one of the things we discussed this afternoon, which I thought was very useful, is that if you create a model that allows for innovation and the investment of capital into the entity, there's the less, I think, opportunity from just a market-driven point of view of the entity walking away from that. That if they have some violations and they just fold up their tent and move down the street, that's going to be less likely if you have a situation where you've got outside capital pouring in some serious investment money into this entity. That was not a factor in law firm discipline because there is no outside capital pouring into the law firm. So as we talk about structuring and regulation, I think you've got to keep your eye on that ball, because whether it's a sandbox or some other thing, if you enhance investment, the chances are they're going to want to see it through. They don't want to get decertified, and they're not going to want somebody in the organization fouling the nest and causing a decertification. Last point is that you might also want to think about having some internal accountability for the wrongdoers, because within any organization, there's going to be lawyer or non-lawyer or lawyer wrongdoers who can do some significant harm. We talked about the inutility of having have all those people registered and licensed and subject to discipline, because that is a big problem. But you could have some self-reporting issues, which was a big issue in law firm discipline debate, was whether or not California has never had the rule that the ABA has about reporting someone else's unfitness to practice. You might want to revisit that, maybe, by having the managers or owners of the entity report someone who is not just screwed up, but someone who's committed a very serious violation that violates public protection. All those public entity debatable issues are on the table now as we go forward, and I thought that that was a useful discussion we had this afternoon.
Okay, Lori.
After Mark, I had a whole bunch of things going on in there, and they've all moved around a little bit. I go from our subcommittee where we are talking about rules and whether they should be changed, how they should be changed, and if they are changed, whether the court will even adopt those changes or consider those changes, and what the criteria might be for that, to the discussions that you guys are having, which feel like you're very far, like a lot farther along, which is creating a regulation process as if that were already happening. And I think I just want to ask both groups to consider whether, or maybe I'm just asking a question, do you think it's possible part of your recommendations may be a further task force to discuss the regulations? I'll share that, not shockingly, anytime you say the word regulate, and Lori freaks out a little. These regulations, I think, all have a lot of validity, and I think there's a ton of interesting thoughts and conversations coming out. Whether, as a group, we can all make a determination where it's an up-down vote in the short time we have before it's an official recommendation is feeling a little overwhelming when we can't even get to all of the rules we're supposed to talk about in our subcommittee. So I'm just wondering if, one, have you guys considered recommending further discussion on the process of regulation in these instances? And two, maybe throwing out a cautionary tale of how document preparation services and online tech products have failed, mostly, I believe, in their delivery because of the regulations that were imposed on them. And that is then used as the reason to show that those are bad models, but they could be better models if they were allowed to have more freedom.
Yeah, so what I would say is, and this might not directly answer your question completely, but we as a subcommittee and we continuously will bring it up from various members, that we're trying to ensure that we regulate to ensure the protection of the end consumer of the product, but not as what we've seen historically in ways that then choke out innovation completely. That being said, I think if you hear the wording of some of what we're working towards as recommendations as a subcommittee, I don't think you could say we're being too conservative. I think we're really pushing the envelope, and so I think that we can't throw out what we see is regulation is not a bad thing. We're going to need to talk through it. And I think in terms of will one of our recommendations be that another task force is kind of brought together? I'm unsure of that, but I do know that right now the way we seem to be coming together as a subcommittee is that we'd like to eventually end on recommendations for the report that are going to be things that we obviously will have to sort out and figure out how it's all going to really come in stages, but that are practical as well. And so we're trying to balance those two. Again, like I said, it might not have directly answered your question, but I think it just captures a little bit of what we are feeling as a subcommittee.
Kevin and then Mark.
Okay. I would like a little elaboration on you identified 3 types of entities, 100% lawyers, 100% non-lawyers, combination, something in between. I think that was your point 3.
Yes.
So what we're trying to capture there is that entities that are composed of lawyers, non-lawyers, or any combination of would be allowed. Now, what those entities would be allowed to do from a delivery of legal services standpoint is what we're going to discuss next, because it's going to depend on the different levels of regulation is what we've determined. But does that answer your question?
Okay, it answers the first part of the question. I didn't really get to this. Okay.
Andrew.
Don't ask me a question. I will answer it. The next question is really, I think you said that you were eliminating one of your principles from before, which was the state bar will regulate all the entities.
Correct.
Correct? Okay. Because
now we're only removing that for now. That may end up being one of our recommendations, but we just feel that more needs to be discussed before we recommend what the body of and how it's going to be regulated.
Because this is sort of like my last point. The Supreme Court has said on a number of occasions that it has, even though we have the State Bar Act and the legislature is involved here in California in lawyer regulation, that it has primary responsibility for regulating the legal profession. And I guess my question is it primary responsibility for regulation of the legal profession, or is it primary responsibility over the delivery, regulating the delivery of legal services?
Professor Moore, we have primary authority over the practice of law. Yes.
Okay, so it's the practice of law in whatever form. So as the State Bar being an administrative arm of the Supreme Court, I think we need to think very carefully if you have any entity delivering legal services as to whether there should be an entity other than the State Bar that would be involved in that. That's all.
Mark.
Yeah, these are great questions. We haven't drilled down on this one, but the State Bar, the Supreme Court has, through case decision, authorized certain entities that are not all made up of lawyers to engage in the practice of law. The Fry case is a good example. And they asked the State Bar to do a study, and is there some harm? We need to have more regulation. The State Bar has all that authority. And the legislature, which works with the State Bar, has authorized document preparers and paralegals and things like that. I think if the Supreme Court wanted to step in and maybe expand their roles or do something that says, hey, look, we can have them do a bit more, they would have the ultimate authority over that. Now, could they authorize the State Bar to regulate it or oversee the regulation? I suppose so. I would hope so to some extent. But if it's 100% non-lawyer, there's no lawyers involved at all, it does raise some jurisdictional issues. But I think the Supreme Court would still be the ultimate arbiter of that as long as it's a delivery of legal services in one way or the other. So I think I'm capturing our general thinking without drilling down too deeply on that.
Okay, that's very helpful. Thank you.
And if like I said, if there's any articles, et cetera, that just come to mind, please do share. I think we have our work cut out for us on this one, and we're going to really need to lean on some of the other subcommittees as we work through it as well.
I had one more reaction to your question. As I'm looking at this, I think we're not two ships passing the night in this sense. Obviously, one of the models that we're looking at is the lawyer's involvement, the lawyer, the law firm or lawyer organization, either made up of all lawyers or some lawyers with non-lawyers. And as we know, because Kevin did the memo on this, lawyers can engage in law-related services or non-legal services with non-lawyers right this minute through other organizations, other entities. That's one model. You move from that to an entity with no lawyers, then the rule amendments that you're working on might not fit that model. Whereas the rule amendments you are working on, which I hope one's going to be 5.7, I would hope someday, that would fit perfectly with the work that this committee's doing. So it's not wasted.
I couldn't let the meeting go by without once again stating a point I keep making. The state bar is the perfect entity for regulating this if it was renamed the California Legal Services Board or something along the line that made it broader and made it, the public didn't have the impression it was a bar association. If we, but we haven't had a full-on discussion about that so far. But again, it would make sense. But right now, the state bar focuses on regulation and admission of lawyers. If we want to expand it, I think the name needs to change to expand it, and then it could open up a lot of possibilities in there. I'm going to die on that hill, by the way.
That's one as you can tell, we have we have spirited membership in this subcommittee with a lot of great ideas, and I think the good news is that I do think we're going to be able to land on some recommendations that balance the practical as well as aspirational, and so that's what we're aiming to do.
Lori.
So I'll throw something out there that maybe isn't in discussion yet, and I'm going to desperately look for the article or backup, or somebody sent me a comment. I recently was reading about the discussion around defining law or the practice of law, so similar but not similar, based on the amount of the dispute. And so creating business models where people could provide legal services based on how small the issue at hand actually was, with a heavy focus on that could increase access to justice and innovation, because it would be targeting those places where we have a lot more need. So I'll kind of throw that in, and I'll try to find the information. It was a really interesting study and thought process of saying, hey, why don't we just open up the practice of law to anybody under this threshold? And it was by not entity or ownership, but actually by amount of in dispute.
That would be helpful to see.
Toby.
Yeah, just to respond to that off the top of my head without a lot of thought, it seems to me that a lot of the legal issues that particularly low-income people face, dollar amount is irrelevant. Because if you're being evicted or your children are being taken away, there's no dollar amount that would measure how you would decide whether that non-lawyer entity could practice law there.
I'm not sure. I think the idea was allowing others to provide legal services to those people being evicted. So opening up who can provide legal services to those people so that they have more options than just lawyers. Because a lot of times it may be hard to find representation at those lower dollar levels.
I guess my concern is using dollars as the measuring stick. That's where my concern is, because if it's critical nature of the representation of how it impacts the human being, $1 million case to a corporation might mean a whole lot less than an eviction to an individual. But you're going to regulate the $1 million, require a lawyer for that, but not for the. So I guess my concern is with how you define the cutoff.
I think I think what I'm hearing from you both is similarly arguing towards the same thing about wanting to increase access to justice through perhaps deregulation. And I think, Lori, your point is around perhaps looking at as a easier means to communicate or kind of get this done. But I think, Toby, your point is well taken, that by going with a dollar yardstick, what that may lead to is kind of limiting, even for a smaller kind of landlord-tenant issue, which may lead to someone being homeless. So I think it's actually all going towards the same place, but different angles. One thing that I would say is, which is important, is that we are also focused on not just limiting this subcommittee's recommendations for not-for-profit or traditional areas that have been determined to be where access to justice lives, because it is through our conversations we believe that the idea of opening up and allowing profits to be made in this does not limit the drive to increase access to justice. And so that's an important distinction from our subcommittee too that I think is important.
Jan.
I just want to state that in that email today, that's actually exactly the model that was used in India, where they took a certain number of cases and below a certain point were actually forced into, not forced, but were automatically directed into arbitration. And actually one of my recommendations was to change the small claims dollar amount considerably higher and eliminate the use of attorneys so that individuals could participate equally or somewhat relatively equally, and thereby combine that with the marketing platform that we talked about to actually attract people that don't know they have a legal issue into something like a specialized program that, even though it has a common say case management system or something like that, a common process and workflow, that you could then attract those cases in, get them into something that's below a certain dollar amount, and be able to participate individually. So that's part of that email. I think you'll find good resource.
I just wanted to add one thing that we did discuss as a subcommittee around the fact that most of the time people who have legal issues don't know their legal issues, and there's that bridge the divide. Our hypothesis is that if we open up and have entities that were being described either 100% lawyer, or any variation, including non, that really becomes a marketing issue. And if you look at what's happened in personal injury, you see, were you hurt on a job site, and then you say, oh, I was, and that's how people are now getting it and understanding their rights. We feel in our hypothesizing and triangulating as a subcommittee around the fact that if we do open up this and have these sorts of entities backed by investment, that would be a marketing issue, and that there's actually that wouldn't we could start to solve that problem as well. Whether that's going to happen or not, we'll see, but that is kind of what we've been chatting.
Mark.
Yeah, I'm a little troubled by the conversation in the sense that there are a number of legal matters that don't lend themselves to dollar amounts. And this access to justice issue, I see it as in dealing with a whole variety of things, including parental rights and things that just can't be measured in terms of dollars. These people cannot get access to any legal representation. I think they're entitled to the same access to competent services as the $1 million corporation, and I think that's part of our task. Is how do we do that? And I'm not suggesting I'm not saying any one of you disagrees with me. I'm just saying that's a big challenge for us. I wouldn't want to shovel off people with low-level cases into arbitration automatically, unless they want to go. I'm troubled by that. I think there's too many legal rights that don't equate to dollars.
And I do agree with that, by the way. At least in principle, it's the ODR does not necessarily have to preclude moving on into court. It doesn't actually have to have it doesn't actually have to be required. In the case of India, it is what's the best way to say it? It is mandated until it is objected to. When it's objected to, then it goes straight to the court. So they can opt out is the best way I can explain.
As long as they know they can opt out.
which is part of, yeah, absolutely.
Kara, did you have something?
So I did see the Twitter post on the dollar amount, but was not allowed to comment. But just the idea that one benefit that attorneys offer that I do think that tech could offer if set up correctly is, as we've been discussing today, identifying problems. And a lot of people think they have an under $10,000 problem when they don't. Employment, I think, is a great example. People come in and they say, look, I got let's say it's a $10,000 severance package, and you're like, well, why were you fired? So they think they have a $10,000 contract review issue, and then you start asking what actually happened with their employer, and it turns out that they were just on maternity leave, and that is a much, much bigger case than their $10,000 problem. And that is the benefit of an attorney. So when we're filtering, I agree with all the comments in general that we got to figure out how to get these people into the funnel where they're figuring out whether they have a problem. But we also need to be asking the questions, and then once it's been vetted, say, okay, here's your other option, but not close them down too quickly based on their perceived values of things.
Lori.
So I wanted to clarify a couple of things. First of all, the idea of personally suggesting an idea of a dollar amount as a threshold isn't something I feel great about. What I'm going to do is be realistic about the idea that for all of those landlord-tenant cases that you're referencing, Toby, there's usually a lawyer to represent the landlord and no one to represent the tenant. So I would submit that we already have data that says those people are not getting lawyer help, which may be the best case scenario. I actually agree with all of the comments. I think there are tons of places where lawyers are needed, but they're not, either because people don't choose to go to lawyers, they can't afford lawyers, or they're just, our system simply isn't able to handle that. I think the idea of a dollar amount is just simply to acknowledge what is actually happening. I think if we look in the court systems and we look at real data, we see how many people are going unrepresented. And if we look at those numbers and the people who are going unrepresented, most of the time it is the people who are up against the landlords. So for me, if I'm thinking about what we're tasked as a task force, how do we increase access to justice through innovation? We have to open up innovation to those who don't think like lawyers, who are risk adverse, who are creating lots of solutions sometimes before they understand the problem, who don't understand product design for technology, all of these things. And so the idea of using a dollar sign isn't really about saying those items are less needy or valuable or worthy, but really saying that's how our system's already set up. Whether we think it should be that way or not, anytime you go into small claims court, you are seeing a lot of individuals who are not represented who should be. And how do we fix that, I guess?
Toby?
Except that in California, at least, lawyers aren't allowed in small claims court.
Oh, well, see, that's something,
Today.
I just learned something amazing. I did not know that. Good job, guys. No, I actually didn't.
This is an appeal.
So that's actually very interesting. And what is the threshold amount?
75.
10,000?
10,000.
So that's an interesting idea, and it almost feels like it supports that same idea. If lawyers aren't allowed, if it's less than $10,000, then people should be able to access delivery of services under that threshold from anyone who's not a lawyer. You guys have built your own sort of statistics that might back up that idea. That's very interesting. Thank you, Toby.
Yeah.
Simon, did you have something you wanted? Okay. Well, very interesting discussion. Randy, where are we?
I'm impressed with Judge Chang's filling in for Abhijit in his absence for the chair in moving their agenda forward. Early on, I think it was at the first meeting, I presented the MJP Task Force's Supreme Court report as an example or template of what some of the content would be needed for our tentative report. And so we developed an outline based on that. And some of it is very groundwork, very foundational. So if we're going to talk about reforms to practice of law, what is the practice of law? What might there be proposed new exceptions? What would those exceptions include? Then there'd be a section of the report that basically recites what are the current regulations. So appreciation to that subcommittee for handling a lot of that groundwork for some of that. And the other subcommittees are a little bit more dependent on where your recommendations are. And so the Rules and Ethics Opinion Subcommittee, their recommendations are all going to turn on what happens to each of the rules that's on their list. And if there's any ethics opinions that they think might be needed or might need to be revisited, et cetera, depending on whatever are the ultimate recommendations of the subcommittee. So they do have a little bit of a following act to do with regards to the development of the proposal. But I did encourage them at their session that they could look at the rule amendments and then look at them conditionally in terms of if there is an entity regulation model, what would the amendment to the particular rule be? And they had in their materials this time two different sets of examples. One was the ABA MDP task force, which was actual illustration rule language, as well as the California MDP task force, which didn't give you red line strikeout rule language, but gave you the description of each concept that would have been needed for the 2001 California MDP pilot program that they had envisioned. And so either one of those routes would be appropriate for your section of what's going to be the ultimate draft report, which is what changes, if any, to the rules and what ethics opinions, et cetera. So I think we're on track. One thing I want to remind people is that if you have any other categories, topics, or actual questions for the survey to send them on through, because we'll be working on that before the May meeting. And with the chair's permission, if maybe Toby or Bridget wanted to speak to this Friday's Ethics Symposium panel.
Sure.
Bridget, last.
So timing-wise, the survey's going to go out when? And when will the results come back?
The results would come back by our August 9th meeting. The survey would go out somewhere in, I think it was
June-ish.
June-ish.
Mid to late June. The survey will probably be in the field about 2 to 3 weeks.
3 weeks.
Meanwhile,
And then they need time, after the survey comes back, they need time to
crunch the data,
calculate the results and put it in.
So meanwhile, we're to write our report before we get the survey?
We'll be writing the report, and then once the report is out for public comment, the survey data will come in at the August meeting, and we'll get to reflect upon our report and what changes or refinements we want to make to our recommendations based on that survey data. And then hot on the heels of that, in October, our very next meeting, will be the public comment, written public comment and the testimony from our public hearing that we'll also have to absorb and respond to in finalizing a report. And so the whole end of summer and fall is going to be looking at the feedback that we're getting and then revisiting each of our recommendations to see how we can improve them.
And special thanks to Joanna and Kevin and Alan for graciously volunteering to help with the questions. Our next meeting, I believe, is May 13 in Los Angeles.
I think before we adjourn, I think I was asked to do something on the symposium.
Yes, yes, go right ahead.
So this Friday, here, no, in LA, in the LA office of the State Bar, right.
I hear he means LA.
Yeah, at home. The State Bar is sponsoring its 23rd annual Ethics Symposium, which is a day-long program of panels talking about various ethical issues. The first panel, the program starts at 9:30 in the morning, goes till 4:15. The first panel at 9:45, 9:30 is 9:45, Recent Developments in Unauthorized Practice of Law. And it includes on the panel Bridget and Josh Walker and me. So we'll be talking about all the stuff that we're doing on this commission or task force. And then there's 3 other panels on other ethical issues. And it's available either to attend in person or it'll all be streamed and can be accessed online. It costs either way. It's not a free streaming. But it should be an interesting discussion. And I know on our panel, at least, we've got a good chunk of time set aside for questions and discussions, so we may get some feedback on the kinds of issues we're talking about from most of the people who attend tend to be people who are ethics nerds, but a lot of general lawyers attend as well.
Just tell them we're considering 100% non-lawyer companies.
Right.
No UPL.
Practicing law.
Practicing law, that's right. Okay, anything else for the good of the order? Thank you all very much for all your hard work. We look forward to seeing you in May.
All right.
So again, you guys don't mind if I stay anymore?
No, please.
It's just nice to have, secure
Yeah.
internet connectivity.
Yes. Yeah. When do you leave?
Oh, tomorrow morning.
Oh, okay.
Awfully good to see you, Greg. I just got an email from Elwood Louie and told him I was sitting right next to you. And
how is this way?
he's good.
See you next time.
Yeah, well, actually, next week I won't be here. It's the only meeting I'm going to miss because I'm getting married 2 days before. So I'm
So you're not going to go to the May 13th?
May 13th.
All right,
I'm on my
well-
honeymoon.
Wow, congratulations. I had no idea.
Yeah, thank you,
Wonderful.
yeah.
Good for you. Well, we
Well, I
will
guess we
miss
should wait to
you.
say congratulations
Yeah,
until the day.
well, she won't say no, I hope, right? It's a formality at that point.
Here, here. I think it's you too, isn't it?
Yep.
Yeah.
Yes.
Always.
I will be there.
The magic word.
I don't think so.
Simon, thank you so much. This was so wonderful.
It's so awesome.
Great to listen and
Yeah.
sit back and thank you for your time.
Thank you. Making up with